one announcement before we start.
You do? Okay. Good morning, everyone, and welcome. Today is February 10th, 2015, and this is a regular meeting of the members of the New York State Liquor Authority. In attendance is Commissioner Kim, Chairman Rosen, Commissioner Green is absent. General Counsel Flug is here, Deputy Commissioner O'Brien, and myself, Secretary Held. The next regular meeting dates are set for February 24th, March 10th, and March 24th, all to be held in our New York City office with video conferencing available in our other office locations. Items will be called in the order as they're signed in, first in Buffalo, then Albany, then here in New York City. When your matter has been called, please approach the podium and state your name for the record. We ask that you state it clearly. Chairman indicated he had an announcement to make.
Yes, very quickly. Sometime today, the authority will be posting on its website a draft advisory with respect to retailers and trademark agreements. Sometimes it may involve wholesalers as well or manufacturers, and it's an advisory that the board will be considering and will affect all three industry tiers. So I suggest that folks look at it. By the end of the day, it should be up. Thank you.
Okay. As a matter of courtesy, we ask that you silence your cell phones. First item in Buffalo is item 237, Hornell South Side.
Good morning, Chairman. My name is Thomas Keefe. I'm an attorney, and I represent the applicant this morning. And thank you for hearing us, and as well as Commissioner Kim and Madam Secretary. I would like to start by saying that on Friday I did email to Madam Secretary some additional letters mitigating and in support of the application we have for reconsideration. And I can tell you that I did receive one since then, and I know the local rule that we should try to have them to you at least 2 days ahead of time. So if the chairman doesn't mind, I'd like to submit this letter at this time. And
why don't you summarize it for us? Tell us who it's from, and just in a couple of sentences, summarize it, please.
Thank you. I'll do that, Chairman. This is from an interesting letter from Larry and Rosemary Gleason. These are the persons who operated this facility for decades before it was purchased by my client. And interestingly, not flattering, of course, is having to write a letter and for a good friend, as it's turned out over the years. But one of the things that is in the letter, and I'll be short here, is the Gleasons lost a son. He was killed in action, and one of the things they concentrate on in their letter and they write about is the support that they got from my applicant in the form of, for the last 11 years, he's headed up a committee for scholarship funds. He donates the food, he donates the tents. This is a history of all these letters, and I'm sure that the chairman and Mr. Kim, if you've had the opportunity to look at them, you'll see that this is a pattern, and it's not something that he does for show. It's something because he's a good community supporter, and I'm very proud of my client and all those things he does. And here we are, Your Honor. That's we're before you because we've made an application for a reconsideration. I know that having reviewed the public part of the earlier, I think it was December 16th meeting, there was, the way I would analyze it, a split vote. And what I'd like is through the mitigation that I've sent in and the letters of support, I'd like to answer any questions that anyone on the commission would have, and also if you'd like me to explain further mitigation-wise, I'd be happy to do that at this time. And also
I think, counsel, my main issue was it's the third gambling charge, and that's the first issue, but the more important issue was the bribery charge of $500 to our investigator.
Well, that's a serious charge, and I would simply say that, of course, as an attorney, this matter was also reported to the local district attorney and to the New York State Attorney General's office, and we don't know that there's a resolution, and we don't know that anything else is going to happen. But almost in the the style of an Alford plea, we're here to say we're not going to debate what the findings were. We're going to admit to it, but we certainly have some circumstances that probably would not be best to get into today because they could have a bearing on something that might happen down the road. But I'm going to tell you, that's not part of the style of my client. There's never been a history. You can go back, Mr. Chairman, Mr. Kim, you can go back and check V&T records. He's never been arrested in his life before. He hasn't had a parking ticket. This is totally out of character, and he's learned a lesson here. And he's got people, he's got the mayor of the city, he's got the sheriff who after 28 years, this is the elected sheriff, has come out and said people need to be punished for these kinds of things. But he felt that in a case like this is not what the punishment is intended to do. What he needs to do is stop that kind of activity.
With the Attorney General's office?
As far as we know, nothing's happened at all.
No information on it.
It's a year ago.
One of the things I would like the Commission to possibly consider, if you're troubled by going forward with just the reconsideration offer that was made, almost a contemplated suspension that might last for 6 months, in a conditional discharge of that and an adjournment, so that if anything were to happen during that period of time, it would be a no-fault suspension at that point. My client has told me, I'd do that in a minute. He says that this has changed. We've educated our employees. I know that my conduct will never get to the point where, I'm going to have to be standing before this commission again. And it's just something that I suggest for the...
What's that suggestion again? Can you please repeat that? What was the offer?
The offer would be a $20,000 fine and also a suspension that would be adjourned in contemplation of dismissal if during the next 6 months nothing happens. But in the event something does happen, another occurrence, another violation, he'd be immediately suspended for 6 months.
Sure, okay. I'll accept that. And I'll grant a request for reconsideration based on those terms.
All right, one other thing. Too, so there'll be a $20,000 fine that will have to be paid within a month or so. You'll get notice from the Secretary's office. And what we'll do is a 30-day deferred suspension starting today for a 6-month period. If there are no violations in the ensuing 6 months, the suspension by its own course will no longer apply. So that'll be automatic. The board won't have to act on it. Is that acceptable, counsel?
It is, Mr. Chairman, with one caveat, though. There was, during this whole period of time, there's another unresolved violation that we would like to make it part of this final settlement if we could. And
Good morning, Chairman. Good morning, Commissioner Kim. There's a new notice of pleading out for the premises, just so you know.
Okay, what does that involve? What are the charges in that?
There's 4 counts. Do you have it with you?
there was...
You've got gambling on August 5th of gambling charge on August 5th, 2014. They got an improper conduct. Oh, that's odd. Hang on. Nope, I'm sorry. I'm just running out of space on my computer here.
So there's another gambling charge from August? This is after being charged with, in this case?
There was a poster board with numbers on it for a baseball game or a football game, Your Honor. And a statement was made in December when he was interviewed by Ms. George. That was not included in the statement that was submitted, which was acceptable to Mrs. George. So
she asked me if I had removed it. I did remove it.
It was just issued January 23rd of this year.
January 23rd?
January 23rd.
Of this year.
Of this year.
And after that.
Right, but they also,
charges were from 2010.
they have purchase from an authorized source and sale for resale on December 29th of this year. And there's unauthorized ad bar August of 2014. Seems to coincide with the gambling charge.
All
So
right,
it looks like it cleans them up for this year.
The notice of after those incidents occurred, though. All right?
Yeah.
Okay, so he wasn't on notice at the time that he was being charged with this
The notice of
violation.
pleading was dated for case 95526, the one that's before you. The notice of pleading is dated May 14th.
May,
May 1st, 2014.
so it did go out before the
Yeah, so
August incident.
That's before August.
Yeah, all right.
So, counsel, you understand our issue, right? We had three
absolutely.
violations for gambling. The notice of pleading for the third gambling charge went out in May of 2014. And then in August, we have another gambling charge. On top of that, the other three counts that we're talking about. So while I do commend the applicant for his community service and his community activism, as a licensee, he's not fulfilling his responsibilities properly. And for me to have gone from revocation plus $1,000 bond to what you had just offered, I thought that was very reasonable based on what you had presented. But considering these additional charges, it makes it very difficult for me to have to change my decision from the prior meeting.
Well, I respect, of course, your opinion, Commissioner, and I would simply say that as this history became known to myself as counsel, to the local people who are community leaders, et cetera, a lot of discussion happened and a lot of changes were made. And point in fact, we're not here to try to cover it up or put vanilla on it. We're simply saying this happened and it's not going to happen again.
I'd like to hear from your client as to,
Yeah.
after he gets a notice of pleading in May of last year, in August he commits the same violation again. I'd like to hear what his explanation of that is.
I'm sorry, I'd just like to let the members know the number of gambling games that were at the location. There were dice cups, Super Bowl pools, 50-50 boards, National College tournament.
So it wasn't
pool.
just one activity, it was multiple
No,
activities.
then
Yeah,
there
it-
was a Monday night
So
football.
it begs the question, are you running a gambling operation or are you running a
No.
bar?
Yeah, it sounds like Las Vegas.
No, sir. If Miss George, the investigator, she could even explain, we've had a conversation in detail. There were things that I had left, that of my own negligence, underneath the bar, and I made it clear to her, and I actually had her write it in a deposition, that those were things that I had been charged before. My own fault, I didn't get them out from underneath the bar. And she even asked me when Mr. Keefe and I sat in her office, she said, "Did you get those other things out of your bar?" And I said, "I'm not sure what you mean." She goes, "Those other things that and I said, "Absolutely." And when I sat with her at my table at the bar, when she came in, she said, I said, "Ma'am, these are the things that I got in trouble for before. That's what I'm under investigation before. What I'm under investigation for." And she said, "Well, why are they still here?" And I said, "I don't know. I just didn't pay enough attention. And I'm here to tell you that I'm going to pay entire attention, be there every day." And I walked away from my teaching profession to do this, and this is my life here. And I just want to assure you that I'll be on top of things. This won't happen. I sent my bartender.
All right.
The bartender
Investigator
classes.
did note that it was his statement that all of these raffles, there's a gun raffle, motorcycle raffle, were no longer going on. That it was his statement.
All right, I'll stick with with what I voted for, except it'll go to 25 from 20,000. It'd be 25,000 with the deferred 30-day suspension would be.
Deferred 6 months suspension, right?
Well, the deferred suspension for 6
For
months.
6 months for a
Suspension would be 30
days.
Still give him a shot at writing over.
I mean, are you, could I speak to your client for a second, please? Are you fully aware of all of the laws that you have to comply with? I mean, do you know what it means when you put an unauthorized source? Do you understand what it means when you add an unauthorized additional bar?
Yes, sir. And an additional bar was essentially was a sink that was sitting outside. It wasn't a bar at the time. There was a piece of paper on it that said the amount of beers for when we have outdoor events, like we had just purchased a not a caterer's permit, an outdoor permit when we had a benefit go on down there. We were able to legally sell alcohol outside the premises. And that was the second bar that she was alluding to. Miss George and I spoke about that also when we met in this building. I believe it was December 29th. And she...
Thank you. In lieu of the new charges, I'll go with the $25,000 civil penalty, but I'd like it to be a one-year period for the deferred 30-day suspension.
I'm fine with that. We'll go for 1 year starting from today.
Thank you very much.
All right, thank you.
Cover both cases.
Yes, the other cases
Yep,
you
I'll put
covered.
it in there. $265, Gap Partners 4 LLC.
Good morning. My name's Patrick Burke, B-U-R-K-E, and we are requesting a license for a new build wine and spirit store in a development in Rochester, New York, called Citygate. And it's a redeployment of a city property that's laid dormant since about the 1920s. It's inside the city of Rochester. So I've made myself available to answer any questions relative to our application, which I think you all have.
All right, we had a couple of submissions in opposition. If there's any opposition to the application and they're present, please come forward now.
There's no opposition present.
All right, thank you. Any questions?
I mean, what do you think you'll bring that's different from what's existing there? Because currently there's three other stores within 1.5 miles of your proposed location.
What we'll bring is our store will be a much larger store, 11,000 square feet, have much broader variety of wines that are available for people. So we think we'll have a significant benefit to the consumers and their opportunity to really choose from a very vast selection of different wines and spirits.
Are you familiar with this selection being offered in the other stores?
Yes, I went to the other stores and have gone in each of them. Yes.
I mean, I don't really see of even the four closest stores. The sales aren't that high for any of them. There's one that's at $124,000, another one that's at close to about $200,000.
Right.
An 11,000 square foot space there. Is the market there for that kind of a space?
Yeah, in this development, there's a number of restaurants going in. This is all new build. There's a 145,000 square foot Costco that's going to be opening sometime this spring. It's a new build, all in the same single development called Citygate. So they're estimating they'll get about, the Costco store alone will do about $200 million in sales. So there'll be quite a bit of traffic.
Yeah, I mean, looking at the sales, it seems as if the demand's being met by those four closest to you. And there's a decline in one of them.
I think demand's going to surge very dramatically. I mean, in addition to Citygate, there's also College Town, which is being completed at the University of Rochester, which is about a mile away, which was about Citygate's about a $260 million development. College Town was about a $150 million development, both being completed this spring. So there's the density in that area of people moving there is going to go up dramatically. And just the traffic.
College Town?
It's College Town is a development that was spearheaded by the University of Rochester. And
Is it dormitories for students? What is it?
No, mixed use retail apartments. It's not dormitories for students. So there's a number of coffee shops, eating establishments. It's anchored by Barnes & Noble, a big bookstore. Okay. So there's a number of things going in there.
And you'll be located in the shopping mall where Costco's coming in?
In addition to that, in Rochester, about another mile and a half away, there's a $300 million housing development called The Reserve on the Erie Canal. So there's going to be, I think, 400 new homes and then some apartments going in there as well.
All right, I vote to approve.
I do too. Good luck with it.
Thank you.
229, Niagara Falls Nails and Spa.
Good morning. My name's Chet McKenna. I'm a consultant that did the liquor application for Niagara Falls Nails and Spa. There are two applicants on the liquor license. We're applying for a TW license. It is a nail salon. The consumption and sale of alcoholic beverages will be solely for the open area inside the salon. The back rooms that are in the back will not serve or sell or consumption of alcoholic beverages in any of these rooms that are in the back. We are here to answer any questions concerning this application.
Has this been approved by the health department? Or is this allowed by the health department?
Yes, we sent a letter to the liquor authority that it was approved.
Yeah, because I thought in New York City, I know salons, they don't even allow the owners to serve even tea or any kind of liquid for, I forget what the exact reason was, but it had to do with the chemicals that were around or the hair that falls in there and whatnot.
I don't know. I know plenty of people do it illegally.
We're trying to do it legally. The applicants can answer that the health department was there and they gave them a letter.
Maybe it's a city ordinance.
Yeah.
Okay. Yeah, I approve.
I do too. Thank you.
Good luck.
Thank you very much.
259, Pyramid Inn.
Good morning. My name is Lindsay Savakis.
I'm David Safakis.
I'm Beth Savakis. We have the questions about the corporation with David G. Savakis.
Yes, you know, one of the key rules in the statute is that the people having any kind of an ownership interest have to be disclosed as owners in their, to the authority, and that seems to be a major issue here.
I really don't understand really what we're talking about. I'm so sorry. I rent the building to Pyramid Inn. I'm the landlord.
Who runs Pyramid Inn? Who runs Pyramid Inn?
I own the building. I rent it from them.
So the two of you jointly own the building, and then you run Pyramid Inn, correct?
No, excuse me, sir. I, along with my sister Beth and my other brother David, we own the land, we own the building. Lindsay leases the building and the land for us. And that's been going on for 30-some years. Before Lindsay got involved, it was my father, and that's how it was set up through him. She's only the landlord leasing the building and the land.
Right, and that's how it's supposed to be on, not only on paper but in practice. But based on our interview with our investigator, Lindsay stated that she does the hiring and firing, but you do as well. Her father, you, does as well, and you're also responsible for keeping the business profitable, not the building or the land. And she stated that you order the liquor, you sign the business checks, you perform most of the bookkeeping duties, Lindsay denied putting any personal funds into the business and stated that she just receives a paycheck. Now that to me doesn't sound like a person who's running the business. It sounds like somebody who is, as Lindsay also said, I'm only the figurehead, quote unquote.
When we were first investigated by Kathy George, it was back in 2012. Since then, I've became more, like, now I do all the bookworking. I do a lot more. Back then is when it first got put, back then my grandfather first passed away. So I was just still learning the business, and my father was helping me.
Who was signing your paychecks that you received?
We both
We
did.
both do.
That's the way it was set up 30 years ago when our father was alive. That's how
Yeah,
he
but
just...
if you're signing a paycheck, how can you say you have nothing to do with the operation of the business?
I understand what you're saying, sir. I do. So this will never happen again. I mean, we didn't know. Honestly, I did not know that. I mean, I just thought I was helping her move things along. So that's
Have
not
you
an issue.
changed
It's an
that
issue there,
understanding
yes,
now?
but that can be
Has that been
corrected
changed?
immediately.
So it
I'm
hasn't
sorry?
changed yet.
It can be changed as of right now, yes, because we weren't aware of.
This is
Honestly, we're country people. I don't know how else to say it, but
But this
there
was from
no intent.
2012 that BCI George
Yes.
visited you, and we're now in 2015.
And you have had discussions with counsel's office.
No one made this aware to me till about a week ago about this paperwork deal through Jamie, is it?
Yes. Morning again. I spoke with Lindsay and another female relative of hers several months ago when the notice of pleading was issued in this office, and then I had discussions with Lindsay on the phone recently, Chairman.
So prior to a week ago, the conversation the gentleman referred to, had you thoroughly discussed the issues that we're talking about today that they say they know nothing about until a week ago?
I have never spoken with this gentleman.
Right.
I have spoken with Lindsay and her aunt on at least 2 occasions regarding what needed to be done. I explained that they were probably going to have to revise the corporation, add the individuals who were in fact active and acting as the licensees, and that they would have to file a corporate change with us. So that has not happened, but we did have a discussion about it last week, and I said if they were going to do that, it would have to be done with some expediency. I was concerned about whether or not any of the individuals could be disqualified for certain reasons.
Yeah, well, we've got 2 of the 3 individuals accused of have felony convictions. And
Yes.
somebody with a felony conviction cannot be involved in running a licensed premises. The law is very clear about that, and that's the concern here. And I'm a little concerned that the way you started off today in addressing us was that you're totally confused about why you're here in the first place. So you gave the impression initially as you stood there today that you don't know what this is about. It's about people with felony convictions not being allowed to run a liquor business. Does that help you?
I do not have a felony, Mr. Chairman.
and I do not have a felony.
My understanding is her brother, who's also listed as a owner/cook in the records.
He doesn't, that's what it states.
That David A.
Yes.
He has a felony conviction and does not have a certificate of relief from disabilities. I was a little confused about the status of her aunt's conviction.
You're talking about
Lindsay-
Beth now, correct?
Beth.
Is that Beth? Yes.
Yes. Lindsay seemed to believe that she had a certificate of relief from civil disabilities, but I had some concerns that may not be 100% accurate. I haven't seen any paperwork, and Lindsay doesn't really know whether that's correct, I think. So I think her aunt can probably address that.
Beth, would you like to address?
I'm deaf. I have a hard time understanding what she did. She is.
Mr. Chairman, may I speak, please?
Do you have a felony conviction?
I do,
The
yes.
Beth.
Yes. Yes.
And what was that for?
That was drug conviction, conspiracy to transport.
And do you have a certificate of relief?
Yes, but I do not have it on me.
But you do have one that was issued by a court.
Yes, there was an issue by Judge Shrekney.
Okay.
I released-
My suggestion is we adjourn this for a month for them to clear everything up, and if they don't, they lose the license. If they clear it up, we'll impose a penalty, monetary
Chairman, wouldn't
penalty.
they
Do you
need
agree?
just a whole new
I'm sorry?
Wouldn't they need a whole new license
Application.
with all these people disclosed?
Well, corporate change application, I think, would suffice, would it not?
He asked for the personal questionnaires, fingerprinting, and all of that information.
I just want to see the filing. So they'd have to file a corporate change application within a month. So let's do that. All right, what we're going to do is we're going to put this over for a month for you to file the necessary paperwork with the authority to clean this all up. If you need to, you can consult with our counsel, Ms. Gallagher, before you leave the office so you're fully informed about what you need to do. If you do that, you file the appropriate paperwork with us. When the case is on again in a month, we'll impose a monetary penalty for the violations here, but we won't impose a penalty that would lose you your license.
Well, you'd also have to disclose David A. as well. Is he involved in the business at all?
Yes.
Okay, so please disclose everybody who is either an owner or going to be a manager on your application.
Okay.
Let's have a date.
Mr. Chairman,
Be March 10th.
Okay, this will be on March 10th. Thank you.
Thank you.
is there any way we can converse for 5 minutes before we leave?
All right, is there anyone else in Buffalo?
There's no one else in Buffalo.
Thank you. 66, Rio Music Theater.
Good morning.
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 My name's David Garlock, and I've applied for a liquor license for Rio Music Theater.
Okay. One of my concerns that I'd like you to address is this location had a very bad disciplinary history with the authority, and in fact the license was revoked, which is a very extreme remedy. You're going to have a dance floor, you're going to have a DJ, you have no background in this industry at all. What are your plans with respect to who's going to be managing the premises and make sure that it's run as a tight ship and the problems don't reoccur? Because sometimes a location will attract the same people, and your method of operation is not that different from what was there before, and so I'd like to hear you with respect to that, please.
Certainly. Well, I have 3 daughters in their late 20s and early 30s. One works for Kodak. She's a biologist. My other daughter ran a club in Boston while she was in college, and she's back. And they're going to help me run the club. I'm in the lumber business, hardware business, and they're not really interested in that. So I'm pretty much doing it so they have a forum to work at. I would own the club, I'd own the building, and I would help them manage it. But I have 40 years of management experience in the lumber business and the real estate business, as far as business goes. I was told, my lawyer was told that back in July that the club's license was canceled, and it wasn't postscripted, and that's why we went ahead with all of this. Now I found out that it was revoked after that. Mm-hmm. So I guess I'm a little confused because I thought we were going ahead in good faith. And I have no record. I've got a good reputation in the community. And I want to go ahead in a good way, and I want to provide employment for my daughters, of course. And I don't know what else to say.
All right.
So you're the landlord on this property. So that while the previous licensee was your tenant, correct?
Pardon?
You own this building.
Well, it's been transferred over to me, but I don't have the mortgage on it. I'm going to get them as soon as I get a license. If in fact I do, then I'm going to get the mortgage on the building as well.
So you didn't own it when the previous licensee was there. You're purchasing the building.
No, I did not. I did not own it.
And you have no relationship with the previous licensee.
I just know who he is. We live in a small community, but I don't have any relationship with him other than knowing his name and who he is.
You've never met him, you mean? You just know of
I've
him?
met him. No, I've met him and I know of him.
Are you aware of the problems that did occur at the premises?
Pretty much, I became aware of them after I started to apply for the license and do all the paperwork.
All right.
I mean, there were very serious charges which led to the revocation. So have you ever had a conversation with him about how he did his operations and how you could possibly learn from him?
Well, I talked to him, of course, a little bit about it, and pretty much what he told me was that I don't think he was very hands-on. He wasn't there very often, and he just checked in, and he had a manager manage the place for him.
And in your case, you're going to have your 3 daughters manage the place?
Well, I'm going to have 2 of my daughters manage the place. One will do maintenance, and she's a maintenance person. And I will also be on premises at certain times.
I think we need your daughters disclosed as well in the questionnaire forms, then.
Even though if they're just working there?
Well, if you're not going to be there and they're managing.
Well, I'm going to be there pretty much when it's open. We're going to be open a couple days a week.
They need to still be on the license, right? They need to be on the license?
So, if they're not receiving it, if they're receiving a salary and they're just managing, they do not have to be on the license. When we stop asking as an automatic requirement for the person who questionnaire the manager, but if they're concerned with the supervision of the premises, then we can certainly.
Do they have any ownership interest in the building or the business?
They do not. No.
The applicant principal is one of 5 persons, Charles Garlick and Sons. Who are the other 4?
The applicant?
Well, I have here Charles
I'm the
Garlick.
only applicant. That's the corporate. I own part of Charles Garlick and Sons Corporation.
Right, and that's for, so that entity owns the building?
No, I will own the building personally. Or Real Music Theater Incorporated will own the building.
Real
Charles
Music
Garlick and Sons.
Incorporated, and who are this? Are you the only shareholder for Real Music?
Yes.
And that has no affiliation with Charles Garlick and Sons, then?
It does not. Charles Garlick and Sons is a family business. It was my family business from 1903. That's when it began. And we're the 4th generation. We have a lumber yard, a hardware store, and a realty company.
All right. Well, I mean, just understand because of the history, we're very concerned, and I'll approve, but just I think there'll be a very close monitoring of the premises because of the history.
Which is the problem. I'm coming in brand new. I don't really, I'm not associated with the people in the past or the building.
All right, I approve also, so good luck.
Okay, thank you very much.
266J, JSG Management Services.
I can go ahead.
State your names for the record.
My name is Elmer Aberkeesh III. Law offices of Elmer Aberkeesh III, PC in Albany, New York. To my right is Joseph Glick, the licensee and owner of JSG Management Services.
All right, do you want to make any comment before we impose a penalty?
Yes, as the board is aware, Mr. Glick has voluntarily surrendered his license and consents to the revocation of that license. That was done after he ceased operations on January 1st of this year. Mr. Glick has also agreed to forfeit return of his bond and licensing fee, and I would politely suggest to the board that that is more than an adequate penalty to address the charges against him. Mr. Glick is out of the bar business and has no intention of returning.
The licensee was asked to surrender his license prior to that, but insisted on being open through the holiday season.
All right. Is there anyone else there who wants to comment?
I think Mr. Gee is here from the board.
All right. We'll hear
Excuse
him.
me.
I'm just going to make a few brief comments. Thank you, Mr. Chairman, and Commissioner Kim. Like I said, I'll be very brief. If this concludes this matter today, I want to thank two entities, particularly Zone 2 Enforcement for the incredible work they did, and also I want to make it on the record to thank the Troy Police Department, who throughout this matter have been commensurate professionals and honest and decent public servants. That's my statement.
All right. Ready?
Yep. All right, I'll accept the revoking bond.
All right, and I will too, and I also want to thank Supervising BCI Joe Finelli and the BCIs who worked on this case, Martin Rafferty and Chris Del Pozo. It's, as I go through the file, this was at times a difficult matter, and I think the work they put into this is showing in the disposition. Thank you, everyone.
.249, Mama V's.
Good morning, Board. My name is Michael Kuroda, an attorney for Mr. Scott Schreifels, the proposed licensee for Mama V's, which is contractually engaged to purchase the Stadium Cafe in Saratoga Springs, both the building as well as the ongoing sports bar.
My name is Scott Schreifels.
I just want to correct the record to state the city of Saratoga is not in opposition to this application. We received opposition from the commissioner.
Right. All right. There's nobody appearing in opposition to the application, is there?
No, there's not, Chairman.
No. All right. As you know, the quibbling is over the hours, whether or not these premises would be open till 4 or 2 o'clock. Can you just briefly summarize why you think it needs to be 4 o'clock? The argument being made by the Commissioner of Public Safety is that they have limited enforcement resources. There is an area of the city around Carolyn Street where a lot of the late-night places are, and that's a big burden on the Saratoga law enforcement. At least they can focus their resources there, and they're concerned about 4 o'clock closings being extended to other parts of the city, spreading them too thin. So if you could briefly address that argument, please.
Sure, Your Honor. I would like to point out that the Public Safety Commissioner at the last City Council meeting had proposed a resolution to define, I think maybe you were provided a copy of that proposed resolution, that nightclub district, of downtown Caroline Street area, approximately a 2-block radius, that he described as a problem area or an area where that's where they focus their resources. It's fairly counterintuitive and, in my opinion, patently unfair to say, hey, there's a problem area in our city, let's reward them by allowing them to stay open until 4 in the morning while punishing every other law-abiding licensee in the city by shutting everybody else down at 2 a.m. I don't believe the Commissioner set forth any facts, nor could he, because they don't exist, that the Stadium Cafe, the location, has been a problem area, that they've had to expend police forces there or resources there for any reason, let alone between the hours of 2 a.m. and 4 a.m. The city of Saratoga Springs is a very seasonal city. Summertime, especially track season, a lot of places do choose to stay open till 4 a.m. And he would be the only one limited to the 2 a.m. cutoff if you so impose that restriction. The Commissioner of Public Safety up in Saratoga has tried numerous times over the past 5 or 6 years to try to get the bars in the downtown Saratoga district to close down early. Each attempt has failed. And again, I think this is a way that he's trying to, again, push his policy that apparently has not garnered enough support in the community itself to have been passed previous. And again, it would put my client at a significant disadvantage to have his license restricted while the rest of the city can remain open until 4 a.m.
All right. Thank you. You ready to go?
Yeah. I mean, given your almost near spotless past history without violations and the particular location of your restaurant, and I vote to approve the 4 a.m.
And we do have a letter from the city attorney stating that the city council has no objection to this application. I approve also. Good luck.
Good luck.
264, QRD Holdings.
And Roy and Deborah Holcomb, in Albany.
State your names for the record.
Roy Holcomb. Deborah Holcomb. I would just like to point out with this applicant, in my speaking to Mr. and Ms. Holcomb, there was an availment, I believe, that was insinuated, and actually they totally, in total transparency, admit that he had been running the premises. However, he had been under the impression from professional counsel, a local counsel, that he was operating it within the, that he was compliant. And he had been told that he could operate it under, I believe it was the estate of Robert Wilbur, and told incorrectly. As soon as he was notified that, from the authority that this was not allowed, he immediately shut down. The premises is shut down right now. And there was no ill intent, no ill will. He did not intend to deceive this authority. And I believe Mr. Holcomb would like to state, make a statement as well. Robert? Roy?
Yes. We can't deny it. We were running it wrong. We thought it was structured in a way of us in a managing position. Obviously, it wasn't. I had poor representation. I should have found more qualified people to inform me. We're sorry it went that way.
I'm sorry. There were no other no violations to my knowledge.
All right. All right.
The lack of taxes being filed and no business bank account.
We're working out as soon as we get things established.
I mean, he's going through this process now, being guided, and is complying fully with the taxes, business setup, corporation setup.
Have you been involved in that?
No, but I had spoken to the expediter who he is working with, which is how Mr. Holcomb came to me, and she informed me that he's doing everything that she had asked for.
Mm-hmm.
So, Mr. Holcomb, what stage are you in opening a business account, business bank account?
I can open that at any time now.
He obviously will have to have it open prior to the.
So the place has been closed for now?
Yeah, oh, yeah, it's been closed.
All right.
Yes, it's closed.
All right. I mean, I'm willing to give you a chance here, but please understand that part of having the privilege of holding a license is also complying with all laws and regulations, including filing your taxes and paying all the fees necessary imposed on you by municipalities, the state, the federal government. So I'm willing to approve this.
I'll approve it also. Good luck.
Thanks for your consideration.
Anyone else in Albany?
No, we're all set, thank you.
Okay. 245, LPQ Corp.
It's an offer of $4,000.
I accept.
I do too.
Thank you.
247, 313 Sand Street.
Another offer of $4,000.
47. Accept.
Okay. 217 Surf Ave Wine and Liquor.
Good morning.
Good morning.
There's an application for removal of a liquor store, approximately 900 feet.
What's the reason for moving?
he's doing so well and the community received him that he found a larger space so that he can accommodate them and, of course, make money. And, in fact, the closest store to where he's moving is himself.
All right. Is anyone here in opposition? We had no submission in opposition, so.
I approve.
I approve.
Thank you.
Good luck.
216, Gold and Jade LLC.
Good morning. My name is Han Chen. My client is new applicant for liquor store, and it's a 2,700 square feet.
Okay, if I might interrupt you, we have opposition, so let's hear the opposition, then we'll get back to you so you can address their arguments as best you can.
Sure.
Thank you.
Charles Lynn, I'm representing Manhasset Merchants, the closest store doing business as Young Liquors, Ed Wasmer, the owner is with me. Population in Manhasset is a hamlet in the town of Hempstead, just east of East Great Neck, with a population in 2010 of 8,080. I have the population statistics as Exhibit 1. It's a 3.4% decline since the census in 2000. And as to the zip code in that area, 11030, the population has been stagnant from 2000 to as recently as 2011. There's no new construction in this area. It's basically rural. There's no new commercial construction in this area. The applicant is at 280 Plandome Road. The closest store is my client, Young Fine Wines, right down the road, approximately 900 feet, less than 0.2 of a mile from applicant, and both locations are right in the middle of the hamlet on Plandome Road. This store has been serving this community since 1933. My client is the fourth one that has owned this store, his family. It's a 5,600 square foot store with plenty of parking in the rear. Applicant would be a 2,700 square foot store with virtually no parking as it abuts the train station and has a taxi stand across the street which precludes public parking. The entrance to Plandome Road is from Northern Boulevard to the south. So when you go down Northern Boulevard, there's an intersection that puts you on Plandome Road. Northern Boulevard is the main intersection for our commercial transportation in that area, residential and commercial. The Gold Coast Wines is on Northern Boulevard and is 0.67 miles away and was just licensed by the authority in May 2013. 340 Northern Wine and Liquor is at 340 Northern Boulevard at 1.6 miles from applicant, was just licensed in November 26, 2014, only a little more than 2 months ago. As to sales figures, Young's Liquors, my client on Plandome Road, shows significantly decreasing sales, besides being less than 0.2 of a mile from the applicant. Gold Coast, the second closest store, has no sales history since it was just licensed in May 2013. Varietal on Northern Boulevard, the third closest store, has stagnant sales, even if you were to extrapolate the last 3 weeks of December 2014, even if you were to increase it by 300,000 from that period. And finally, 340 Northern Wine and Liquor has no license history. As I said, it was just licensed in November 26, 2014. What's interesting, too, is that even the fifth closest store, Fine Wines and Liquors, was recently licensed in December 2011, and may be a significant reason for the substantial sales decline of the aforesaid two stores, Young's and Varietal, as Fine Wines opened in December 2011, and substantial sales reductions were registered by both stores, Young's and Varietal, in 2012 and 2013, and it seems like it's more than just a coincidence that those sales went substantially down. It would appear that the package stores surrounding the applicant's proposed location are adequately meeting the needs of the community. When I did a FOIL request with regard to the application, it appeared that the principals had no prior licensing history And it would appear with the number of stores in this area that there's nothing unique possibly that this applicant can bring to this community.
All right, thank you. We'll hear from the applicant now.
There's another opposition.
Oh, I'm sorry. I thought, sorry.
Hi, my name is Samira Lund. I'm from Gold Coast Wines and Liquors. We were established in 2015. Most of the significant reasons for an opposition were mentioned by my fellow opposition. I opened in 2013 towards the end of the year, and I only have 1 year of history, and I just feel that I haven't had enough chance to set up the business or establish the business. I feel that there is not much more need in Manhasset, as I myself am having a lot of difficulty establishing this business right now. And when I had applied for the license, I thought the minimum distance from an established liquor store was 1 mile, and that's why we were in 1 mile in distance from Young's. This upcoming license is only 0.2 miles from Young's and 0.6 miles from my store. So I think all the reasons have been mentioned. If any questions, I can answer them.
No, just for edification purposes, there is no limit to the distance. The standard is public convenience and advantage, so it could be next door for a variety of reasons.
Maybe my understanding is wrong.
Example.
We have your store over a mile away. What did you use to measure the distances?
Google.
Okay. Mr. Springer, are you on this too?
I wasn't, I am now. I represent 340 Northern Wine Liquors. We just got approved last year, and we just got opened November or December. And the distance from our store is probably a little further than these stores, but you know, I remember that application. I remember the competition that was there, and it seems like the area, without addition of our store, is adequately served.
Okay. All right, we'll hear from the applicant now.
I'm represent Gold and J LLC, which is located at 280 Plandome Road, Manhasset. The new package store will comprise ground floor and basement for total 2,700 square feet. And the population increased actually since 2010. The previous opposite Young store says 2010 is 8,080, but actually 2013 the status is 8,481 people, which is a 5% growth in the past 3 years. Plus, the population density, the square feet per mile, is 3,561 person, and comparing 417 in New York and 90 in USA. Manhasset median household income significantly above the state average, which is in 2012 is $104,000, and compared to 2000 is $88,000. It's like $20,000 more in that past 2 years. And as we have received opposition from the other stores, the amount gross sales figure is still like November. It doesn't include the holiday season like Christmas and New Year. So as we have known, Young's Liquor, which is the closest, is over $3 million sales, and the other one is over $2 million. So pretty much they make good money there. And as they mentioned, there is a rail line which crossed the Plandome Road in half. Young's the other side, we are the other side of the railroad. So it's a different. And plus, my client will serve south part of Pandom Road, and many from the rail station. There is a distinct characters of my client, which is a new applicant. The owner is also the landlord of the premise. They bought this premise like 2014, last year, and the owner is attorney to be. He sit for the New York bar exam, and he cannot come with me today. And he was a licensed Chinese attorney in past 10 years.
That's Li Shu? Mr. Li Shu? Or who's the?
Mr. Xu.
Li Shu?
Yes. And based on his Chinese background and with the growth of Chinese migrants to Manhattan, they will bring diversity to this area, like Far East liquors and wines. And a square footage of this applicant is mid-size, and I think it's easier to make clients find their selections.
So I note that Mr. Xu is a PR China citizen, and it doesn't say here whether he's a permanent resident. He's a green card holder? Okay, so on the questionnaire, he needs to fill that in. It's not filled in. There's a space that asks for the alien registration number. Because PR China is not a treaty country, and if he's he may be ineligible to hold a license if he doesn't qualify under those laws.
Oh, he was.
Okay, just fill it in. It's not there, so you need to update and amend.
If this gets approved, I'll make it a condition.
Okay.
Oh, okay. No problem. That's all my representation.
All right,
and
thank you.
Any question you could ask me?
Yeah. With this, we just issued 2 licenses in the past year and a half, and with the sales declining, it seems as if the market's adequately served, so I vote to deny.
Yeah, I have to deny it also based on those reasons. Thank you.
Okay.
261, Grape Wisdom Wines.
Bernard Seidman for the applicant.
Okay, we have opposition from one store. Is anyone present to oppose this? If they are, please step up. All right, we'll hear from you, Mr. Seidman.
Yes. My clients looked around and they found this particular store on 46th Street, and considering it's in the middle of Manhattan, it's really not on top of any of the other stores. The Morel being the closest store, 725 feet away. They intend to open a full-service liquor store, and I've sent it in. Not as a specialty, but they will feature three lines. One being Brazilian wines, because if there's a Brazilian section in New York, 46th Street is it. They will also have a display of New York State wines, and they also will have an extensive kosher wine feature. My clients are anxious to open in this particular location. They feel it's ripe for another store, and there is considerable construction going on now. As an example, there's 71 stories being built at 520 Fifth Avenue, 21 stories on 36th Street, right near this store. On 55 West 46th Street, 34 stories is being built. 701 7th Avenue, the new Marriott, that will have 452 guest rooms. 554 Fifth Avenue, 7 stories, retail and office. 562, 564 Fifth Avenue, 12 stories is being built. 50 West 47th Street, a 21-story is under construction, and 15 East 47th Street, they're going to have 6 stories retail and commercial. So my clients are in an area of growth, and they feel they would be successful and they would contribute to the area in general.
Mr. Simon, just go ahead. No,
Is there any coincidence that you've had a large number of applications in the Midtown area within the past couple of months? You've been here almost at every board meeting with an application in the 40s.
As a matter of fact, I haven't been for a while, and I don't think there's a coincidence.
Okay, that's your answer.
Mr. Simon, I have the same question from the previous applicant. So here on the questionnaire, it says they're citizens of South Korea, which is a treaty country. Just want to make sure that they're legally authorized to be able to hold a license, because there's no other, it's blank where it says visa type or registration.
Mr. Sam Kim has what is needed. Green card.
The permanent resident.
Yeah, permanent
Yeah,
resident.
just please amend the questionnaire to update that information. Okay. All right, I vote to approve.
I approve it also. Good luck.
Good luck.
$177, Space Billiards.
Mark Miller, Miller-Sammy, good morning. This is an application, this is a request for a conditional no contest. What's unusual about the request is that the business has been closed for a period of time. It had been sold, there was a temporary license that was in effect. When the charges came out, the authority 589, this one, so it's been closed. And I brought the current licensee and the applicant. The applicant, as I indicate in my letter, will fully comply with the provisions contained in the stipulation of the city. So I would ask that the penalty suggested be accepted and that the 589 be removed and that the new application go forward, because the current licensee has no intention of going back into business.
Anything? Do you have anything? No? Okay, I mean, I'll accept the, it's already sold, and I think there's been an issue with prohibited hours consumption at this location, so I think the new applicant should be made very well aware there may be a reputation for that at this location, and to enforce that diligently.
Absolutely. They will comply fully with the stipulation. The security guards will be in place. The
2 security guards.
The 2 security guards will be in place. The scanner will be used at all times, and they're fully aware of the problems that the previous licensee had with the premises, and there will be no repetition.
I'll accept the offer of $10,000.
I agree.
Thank you very much. And I ask that. Thank you very much.
266B, Emily's Bar and Grill.
Good morning. My name is Jerome Sussman. I represent the licensee here. This was a disciplinary hearing, and the administrative law judge sustained 5 of the 6 charges. I'd just like to give a brief synopsis of my position here, since I don't agree with her findings on the law as opposed to I don't know what. With respect to the first charge, the licensee attempted to supply the information that the investigator requested. Unfortunately, there was a problem with communication. He said he went there to bring the documents that were requested, and that he was told that the investigator was not there because of a death in his family. He subsequently said he made a number of phone calls, which he didn't document because he's just a bar, principal of a bar. But I can attest to the fact that I have made any number of phone calls to Albany and left messages, and I've been told by the people that I've left messages for after I've emailed them
that they never got the messages. The first thing they heard was from my email. So it's not.
I did a search of the emails.
What's that?
Related to this case, I did a search of the emails, and there was no email.
There was no email from the licensee. I sent an email. The investigator made a request for
So do you have a copy of the email that
books and
you
records.
sent? Do you have a copy of it?
Of the
my email that you sent?
It's in the records that I sent him 90 pages of bills, checkbook, et cetera, et cetera, et cetera. That was admitted that he got them. He subsequently asked for something else, and when he asked for that something else, that was he wanted to see the corporate kit.
Yeah.
The licensee, president of the licensee, we submitted a statement from him to the effect that he went there, went to the Albany office, brought those books and records that were additionally requested, and that the investigator was not there at the time, and that he subsequently made phone calls. This had nothing to do with the email. I submitted the email as a result of a written request from the investigator to the licensee. So 90 pages of bills, et cetera, are fairly substantial and in compliance with his request. And he listed on his request the things he wanted, and I gave him all of those things.
But this was fully vetted at the hearing. The licensee, you had witnesses that testified at the hearing. The ALJ heard all this. Right now it sounds like you're retrying the case.
She sustained 2 charges. One charge that we did not maintain books and records on the premises, which he never went to. He sent the notice, and as a result of that notice, I emailed him 90 pages.
She sustained 5 charges, correct?
What's that?
She sustained 5 charges and dismissed one.
But she sustained the charge of not having books and records on the premises. And as far as the books and records on the premises, since he was never there, he could not have known whether there were books and records or not.
I think if you read the decision, she based it on the fact that they were never produced.
They were produced as a result of his sending a letter to my client. My client then brought all the paperwork to me, and I emailed everything to him.
All right.
And
all right. Anything else?
And it was part of the state's.
But that was fully vetted at the hearing. Again, the ALJ heard all that evidence.
Again, I understand that she heard it, but I don't understand how she could say that we didn't submit him if, one, he never went there, so he could not have. I mean,
he's saying they don't. Basically, he's saying there are no records because they weren't produced. That's what he's.
No, he said there were no. One of the charges was.
I'm reading the judge's opinion.
To maintain records on
do you recall what the judge said in her opinion?
Do I recall what she said?
Do you remember what she relied on?
I don't know what she relied on.
Okay, then move on. I do. I read the opinion. What else do you want to argue?
As far as disorderly premises is concerned, there was testimony by the licensee that this was a situation that happened when an argument took place between 2 people. They put one out, and a little later, the second one left, and as he was approaching, as he opened the door, the guy was in the vestibule and stabbed him. This was spontaneous. The police report shows that they questioned the security guard, and the security guard said, well, no, it didn't happen that way. There was a fight, and these are in her decision. There was an argument between 2 people. The security guard broke them up, put one on one side, and when he went back to the second one, he saw a friend of the first one punch the victim, and he grabbed him and he put him out of the place.
Right. So I think the main concern is he wasn't a properly trained security guard, and secondly, he lied about it happening outside, and then later admitted that the stabbing actually occurred inside. And then on top of that, they try to mop up the blood inside to hide that fact.
Right. And there was testimony that there were blood splatters in various locations inside the licensed premises, consistent with the witness statements to the police officer.
Correct.
So let's hear your argument about the next one. We're not going to try this again. What else do you want to say?
Either way, if it happened inside or it happened at the door, it had to be spontaneous.
Yeah, the judge relied on the fact that you had an unregistered security guard and that it was clear that there were signs of covering up that the incident had occurred.
And the authority introduced in evidence a search from the Secretary of State's office, and that search showed, said that as of the date of October 2014, this man was not licensed. They had 3 other people with the same last name that were licensed, and they had licenses expiring in 2015 and 2016. But if this guy was licensed in 2014 and he wasn't licensed in 2015, it would not have shown up.
So did you
2012 was.
So did you present any evidence to show that he was licensed?
What we presented was a security guard training course approval and a statement to the effect that he told my client that he was licensed.
But you didn't produce a license.
We didn't produce a license. This guy disappeared, and we were never able to find him again.
Okay, the ALJ in her decision doesn't just say that she relied on a document from 2014. She says that she refers to the BCI having done research and found that at the time of his investigation, she doesn't say at the time of the hearing. She says at the time of this investigation, he was not licensed. As a follow-up, I asked our enforcement bureau to double-check that, and I'll hand it up to you now. I have certificates from the Department of State that they received certifying that the security guard had, in fact, been licensed from 95 to 97, but had not ever been licensed after 97. The incident, therefore, occurred, what is this, 20 years later? 15 years later. He hasn't had a license in almost 20 years.
My client did not know that.
So here's the evidence if you want to see it.
Well, again, that evidence may be there.
So your argument is your client didn't know that he wasn't licensed, and therefore the charge should be dismissed.
My client believed that he was licensed.
Well, your client should have asked for him to produce the license. That's his due diligence requirement. He cannot rely on the mere oral representations of somebody that they're a licensed security guard.
She testified that she asked him for his license, and he said he didn't have it with him, he would bring it. And then they parted ways, and she never saw it.
I'm ready to vote.
Me too. As to charge 5, dismissed. Charges 1, 2, 3, 4, and 6 are sustained. I vote cancel and bond.
I would, I'd impose a $12,000 penalty.
How about?
This is or a suspension. This is the first time that they've been before us.
All right, well, I'll take a monetary and a suspension.
So,
a 10-day suspension.
10 days and $10,000?
It's fine with me.
Okay.
Thank you.
Thank you.
266D, 355 West 41st Tavern.
Licensee, Law Offices of Robert Race by Louis Chisari.
Sir?
The Law Offices of Robert Race, Louis Chisari. Good morning, Commissioner. At this time, we are asking for a default to be vacated and to be placed on the hearing calendar to be resolved on the merits.
Why was there a default in this case? I need a legitimate reason as to why there was a default.
Yes, Your Honor. First off, on the day in particular that the license was issued summonses to one of his employees, he was actually had been arrested on a misinformation of a warrant, and he was actually in downtown Brooklyn. He hadn't gotten notice from, we do not know why we did not get notice from the SLA, because he was here several days before the hearing on a different disciplinary matter. Then he was here subsequent to that. He would have been here if he had known about it. He had no notice until he got the default.
He was notified. What about the notification sent to his home?
That's not just the notice of pleading. This was at hearing. This was a default at hearing, so he knew there was a notice of pleading.
I understand that, and Mr. Race, who is his attorney, did not know it. As far as his home goes, he has just been through a divorce. He's not living at his house at this point, and he has in the process of getting the information to the state.
So where is he living?
What is your address?
2 Sherwood Terrace, Yonkers.
And where is that?
Yonkers, New York.
Where?
Yonkers.
And what's the zip code?
I don't know what it was. I'm only there a year or so.
But his attorney was notified about this
Mr.
as well.
Mr. Race has no notice in his office of this, and he's saying he did not get notice of the hearing.
There was a bill of particulars sent to him.
I understand that, and again, Mr. Race is saying he has no knowledge of it in his law office, that he has no knowledge of it. He was here again the week before there was a hearing, and he was here, I believe, subsequent to that, again, without knowing about it. We're just asking that this be heard on its merits. The default be vacated and be heard on its merits.
I'm willing to send it back, but I will tell you this.
And I'm sorry, Chairman, but the licensee had 2 attorneys. He had a different attorney before Mr. Race.
Again,
The hearing was rescheduled because he obtained a different attorney who wasn't available on November 16th.
I cannot speak to the other attorney. I can only speak to Mr. Race. This is the first I'm learning.
Client can.
What happened to the other attorney before Bob?
There was no other attorney.
According to my client, there was no other attorney.
I have here a notice of appearance from Benjamin Korngrat.
Oh, that was, right. That was a long time ago. That was a year ago.
What's the date on the notice of
The
appearance?
date of the notice of appearance is August 26, 2014.
He recommended me to Bob Race.
And then Ms. Chaplin was going to schedule the hearing, and her note on October 17th is licensee retained different attorney who is not available on November 6th as he will be on vacation.
Right. I believe there might have been just confusion between the 2 law offices getting this particular petition.
Given the penalty I have in mind,
Yeah, all right. Same.
So we're going to send it back to council.
I agree.
Let's try to expedite it if we can, because this one came right on the heels of another minor. So if this fellow continues the way he's going, I think the public's in danger. So let's get a quick hearing.
Thank you.
266E, Sajuma Bar, Lounge, and Grill.
For the licensee, again, the law offices of Robert Race by Louis Chisari. Good morning again, Your Honor. At this point, there is a conditional contest plea and an offer of $2,000. Mr. Hernandez himself had to leave the country for a medical emergency.
Do I have the wrong file? I'm sorry. This is 266E.
E, right?
Correct? There was a finding after a hearing.
Yes.
There was no offer.
Yeah, I'm sorry. There was a conditional no contest plea with Mr.
Sajuma
Buckley.
Bar Lounge?
Yes.
When is, I don't have a no contest.
I don't have
plea
one
either.
either.
When was the no contest plea
October
offered?
15th, 2014?
Is this case 96527?
Yes.
Oh, he's making an offer after he received the hearing.
After you received the hearing, I'm sorry.
It doesn't work that way. After you're convicted at a trial, you don't get to tell the DA you'd like to take the sentence will be imposed based on the findings at the hearing, not on an offer at this late date.
Your Honor, if I may speak to the findings?
Yes. No, you may speak to mitigation, but we're not going to retry the case.
Yes, Your Honor. As far as mitigation goes, in regards to the DBA, the client did make the proper applications to the town. He then withdrew that DBA application with the State Liquor Authority, and he's operating just under Sajuma Bar and Grill. As far as the building code violations, they have all been corrected. In fact, I think submitted to the ALJ was the engineer's report and the correction in the fines. And the fines paid to the town of Brookhaven, I believe it is.
All right.
All right. Charge 10 is dismissed. Charges 1 through 9, 11, and 12 are sustained. 5,000.
I'll do 5 also. Thank you, counsel.
Thank you, Your Honor.
201 and 202, Tauser.
Good morning. My name is Frank Morrow. This is Offering Compromise. How are you, sir?
Morning. Okay, we're on for offer of 5,000.
So now, do we need? You said, okay. I guess there's an issue of a door separating the two.
I went to the
bars?
location myself.
Okay.
Location, you enter on the Avenue A side. You
Yes.
go past the bar, hanging right, you go down a set of stairs, there's a double door.
Okay.
The double door opens up into the adjoining premises, which is on, what's the side street? 4th Street? 7th Street. 7th Street. It's entirely possible, and even in question, those doors were closed. They sometimes are.
But why is it a separate premises? I used to
Not
go
a
to
separate
Niagara.
premises.
It was the basement of Niagara. It
It's
didn't
not
have
a
a
separate
different name.
premises. It's
You
the
just
same
called it a
premises.
separate premises.
I'm
That was
telling
your
you
words.
that they try to create the idea that it's two venues. And
it's
sometimes, no, of course not. It's just different rooms. Sometimes you'll have a private party on one side, it will be closed. But I was able to walk right through at 5 o'clock in the afternoon.
And does it dramatically change when you walk through the double doors, or is it just that the double doors are?
Rooms, you know, one
To look.
just change the vibe.
It's all about.
And there's a separate entrance for that other room?
Yes.
And they're connected inside.
And they're connected inside through those double doors?
The doors are not locked. That's just.
Were they swinging doors, or?
Yes. Panic doors that swing out.
I mean, do you need two separate licenses? No, right? I don't think so, yeah. All right, I mean, given that, also the court dismissed the block exit and the maximum occupancy charge, did they do that?
Yes.
Okay.
Sorry.
All right, I'll accept the 5,000.
I'll accept it. Thanks.
Thank you.
218, Liberty Palace and Banquet Hall.
Yeah, good morning. Good morning.
Morning.
My name is Tyrone Prasad. I prepared the application. We submitted the application, and we did come to the 500 feet hearing on August 21st, 2015. And we understand that there was an objection from the community board, Queens
Yeah,
10.
we have an email from the community board saying that they wanted to discuss various stipulations with regard to the operation of the premises, but that they have not heard back from the applicant. So therefore, they say they're opposing the application. So can you summarize what your understanding is as to where you are at the community board? Because they're telling us that you didn't follow up with them.
That's not true. We did meet with the community board, and they offer us.
When did you have the meeting with them?
We had a meeting early in February, because we made several attempts to reach the community board chairman, and finally we get to speak to her early in February.
So what was the date, the specific date, please?
To be honestly, I can't remember the specific, but I did respond to the community board chairwoman there, and I sent her a letter. I personally took the letter over to the office, and I also emailed the letter to her office.
Right.
And I went there, and they told me that she's going to reply. I have a copy of that letter.
Would you hand it up, please? We'll
Yes,
take
sure.
a look at it.
Now, during the 500-foot hearing, you were asked if there would be dancing, and you replied that you were not sure.
Yes.
What does that mean?
Because we are still in the process of obtaining our CFO for the building. And
Does your method of operation include dancing?
no, not at this time. If we going to be including dancing, we'll do an amendment of that. At the moment, no, there's no dancing, because we know we have to have a cabaret license and everything else, and so.
You know, the community board is worried about the increase in the nightclubs that are sprouting out over there. And I think in your letter you said this was really going to be a family-oriented facility. It's going to serve the immediate patrons in the area who are within walking distance, quote unquote. And yet it's only open on certain hours, and you want really late hours. What do you propose? Is it just you're going to hold birthday parties for the people who live right in that vicinity? Is that kind of what your method of operation is?
Yeah.
It holds 250 people.
Yes, it's a small catering hall,
Sure.
mostly operated on weekends there, Because what happened is, like, most of the catering halls around the area there, they don't book small parties like that there for those people, so those people, you cannot accommodate those people. We have a small catering hall there, which can accommodate a small group of people here. And also, the committee board had a problem.
Sorry, so 250 people is small?
That's a good-sized event.
Yeah.
For a private event, that's pretty, you know,
Yes.
that'd be a good-sized wedding.
It's like a wedding.
Yeah.
Bigger than my wedding.
Most weddings around, most catering hall around there, like for instance, you have Golden Terrace, is 800 people. Royal Indian Palace has probably like about 1,000 people there. All the other catering hall around there accommodate well over 500.
What are the days and hours that you're proposing to operate?
We are, well, initially we were asking for the regular what the liquor authority was offering up to 4 o'clock, but the community board wants us.
They want you to close at 12 and you're offering 3. But what are the actual hours and days?
The hours.
Sorry, when they have a special event booked, so
Right.
they might not be able to say specific days, because it should be only when they have a party.
Yes, when we get booked for the party, because if we
So,
stop-
but what, if I come to you and say I want to have an event, what would you tell me the range of days and hours is that I can have an event? Are you available every day for the week?
yes, we are. Whenever you want to book a party, we have to accommodate you.
Okay.
Whenever we also have a parking lot for there's no congestion on the place there.
Where is the parking lot? Because that's an extremely congested area to drive and find parking on, and you say you're going to have valet parking.
I lived around that area there. There's not congestion around there.
On Liberty Avenue?
Yeah, Liberty Avenue.
So where's your parking lot?
It's across the street. It's just this is between 130th and 131, right at 131 at the corner of 131.
And who maintains that lot? Who does that belong to?
We have a lease for that lot. We lease
Okay.
that lot from.
And how many cars does that accommodate?
There's like about 20 cars inside it.
About 20.
20. Yeah,
Well,
20 cars.
if you're going to have 250 people, where are the rest of them going
And
to?
again, Judge, the situation is that most of the people is from that area there. Most of the people from that area, most people, walk to
It just doesn't sound like you need till 4 a.m. if it's a neighborhood kind of a place where most of the people are there. They're going to want to go home.
Right. That's why we're proposing that, we can stop selling, we can compromise and stop selling at 3 o'clock because.
3 o'clock is not much of a compromise.
Well, at 12 o'clock, nobody going to book our party.
No, I could see it being a little bit later than 12, but not 3, not 4.
Yeah, and
Well, specifically, you said weddings. What other kinds of events do you anticipate?
we got birthday parties,
Birthday parties.
The other events that people want to book, they want,
All right, so does a wedding or a birthday party have to go to 3 in the morning?
Sometimes it's a multicultural society around there, a lot of West Indian, Guyanese from different background.
Then they have to celebrate till 3 or 4?
Well, not necessarily have to celebrate at 3 or 4 in the morning, but at 12 o'clock is on country. We cannot operate like that at 12 o'clock. So we are willing to compromise to,
Well, I think 1 o'clock is reasonable for the business model you're proposing. If it's catering to the local neighborhood, I'm sure they also have a very much of a self-interest in not making sure that other people are partying till 4 a.m. while they try to get some sleep. So I understand it is on Liberty Avenue and it is a commercial thoroughfare, but based on the model you're proposing, I'm willing to go to 1 a.m.
I would do 1 o'clock too. Is that acceptable to your client?
Can I just add one little thing there,
Yeah.
Judge? There are, in this location here, there are 3 other bars across the street, which in existence until 4 o'clock.
Yeah, but those are bars. You've been telling us for the last 10 minutes how you're going to be a family-oriented catering establishment. Bars aren't family-oriented.
Right.
So it's a different clientele. You're not competing with them.
Well, the reason bring up the point is that the committee board were worrying about noise and congestion, and so in.
Yeah, but you might have
area-
200 people leaving your premises. How many people are leaving the bar?
But not every day in our establishment. Not every day you're going to have that. It's mostly, I guess, as I say, mostly you have those events. on weekends.
Frankly, I'm a little worried that you use the bars as analogous to your client's operation. And that's exactly what we're concerned about. I'll go with the 1 o'clock. Is that acceptable to your client?
Can I ask for 2 o'clock?
No,
1 o'clock.
Is 1 o'clock acceptable?
It's
We need a
actually,
yes
for
or
me,
no.
it's on weekends, Thursday, Friday, Saturday, you can do 1 o'clock. Actually, I think, actually, based on the location, I'll give you 1 o'clock when you're booking parties. It could be during the week over the summer.
Does your client accept that?
I can I can discuss back with him and,
Okay, why don't you talk to your client and we'll recall it.
okay, yeah,
But it's going to be 1 o'clock if we issue it. Thank you.
all right. And is that for the first term of the license, the 2-year, and then we can request?
You come back in 2 years if he's been a good operator. I'm not going to commit, we're not going to commit the board, but he could come back in a couple of years if he's got a good history.
Just like this location previously had a license before. This location previously had a license. There was no history of anything. There was no noise complaint, no parking complaint, no liquor authority complaint, or nothing like that ever for this location here. So this location has been free and everything has been okay with this location.
You can discuss it and we'll recall.
All right, thank you.
.222 M&J Flow Lounge.
Good afternoon, Vivian Tozaki, attorney for M&J Flow Lounge. Sorry, I took my notes on my phone. We're here because the previous license was revoked because of multiple violations, including sales to minors. We're prepared to answer any questions the members may have, but first I'd like to make a few points. First, my client, Eddie Hernandez, has no connection with the previous licensee or any of its principals. He's been made aware of the violations and has no desire to repeat them. I believe I've brought proof of that. His method of operation is for a bar or tavern with a light food menu, recorded music jukebox, no dancing, no live music, no outside areas. The occupancy is just 40 persons. There will be 5 tables, 10 seats, a 30-foot bar with 12 stools. He will manage the premises himself from 5 p.m. to close, and will employ a security guard. I brought the security agreement that he's entered into with the security company to do ID checks and periodic walkthroughs to ensure a safe environment for patrons and staff.
How did your client find out about the premise if he has no relationship with the prior applicant?
We found out from you guys.
No, I mean, how did he find the actual space for this particular
I just asked him that because it wasn't a purchase of the business. It was empty for about 1.5 years. So I don't. He does sanitation. So was it?
We do service.
Can you come up to the mic, please?
We do service in the area, and I see a for rent sign. I inquired about it, and people who rented it told me it was available.
Are you going to continue with your present employment?
Well, I have part-time employment.
Part-time.
I'm not going that good with the company.
Your hours are, proposed hours are?
Monday through Wednesday, 5 p.m. So he'll be there 5 p.m. until they close. He's looking to close around 11, maybe a little earlier if business isn't so good. Thursday through, Saturday, he's 5 p.m. until as late as he can get 4 a.m. But at all times, even during the weekdays, he's going to have a security guard there. He even brought me proof of the scanner, the 310 ID scanner that he bought with anti-swipe back capabilities, so kids can't try to bring in multiple IDs, and it even has a PIN code on it. So, he's even doubling up on the security by checking that the security guards aren't sitting at the door playing games or something when they're supposed to be on it using the scanner.
Okay. All right. I approve.
All right. I approve it also.
Thank you.
Thank you very much.
The hours.
We never heard back from the meeting before.
230 Bronx Wine and Liquor.
Good morning, Chairman Roach, and good morning, Commissioner Kim. My name is Hu Ping Hu, attorney representing applicant Bronx Wine Liquor Corp. I have standing here Mr. Jianfeng Li. He's the principal of the applicant, and also have the consultant for the applicant, Mr. John Springer. And
Okay. There's another application that shares, I think, one of the stores, but I think we could take this on its own merits. And this is the one submitted first in time in any event. So we'll do this, but if we should issue this, we've got to take that into account on the other one. But I think we can do this one on itself. Any questions, or?
We have a petition to support we'd like to submit.
All right, we'll take it.
I'd like to make some points.
Very briefly, please.
Okay. The agenda sheet describes a strip mall. It's really an 11-building shopping complex with a supermarket, bakery, Chase Bank, electronics store, pharmacy, deli, restaurants. There's population's increased since 2000 by 5.7%. The closest store has increasing sales. If the applicant's going to leave his shoe store to his mother to run, he's going to run it full time. It'll be an open store. It's average size. It's on the corner of 233rd and Baychester. The nearest store on Baychester to the north is 1.3 miles. If you get into a situation about the other store, we don't take a position about the other store, but we do note that they have 5 licensees within 0.5 miles, and 3 of those are on the same street. We're a little bit, we have better distances, and they're not on the same street for the most part.
So I'm inclined to approve this, but do we have to? Should we look at the other one then?
Yeah, I don't have the 232.
Jackie, could you call this one too,
yeah.
please?
232 JP Wine and Liquors. I don't believe anyone's signed in on it.
Okay. Well, it's almost 12, so we can do that one too then. But so let's vote on 230, I guess.
230. All right, 230. I think based on the increasing population and the locations of the others, even though we have issued 3 in the past 20 months, 21 months, 2 of them were further away, and the closest Baychester was 1.3 miles. I approve.
Yeah, also, one of the stores that you referred to, although this is the store on Bronxwood Avenue, although the license was issued in April of 2013, it has been a licensed store since '94, so that issuance didn't add a new license to the area. So I agree, for the reasons stated by Commissioner Kim. It's approved.
Thank you.
thank you, guys.
Good luck.
Okay. Did you want to do 232 now?
Okay, and we have no appearance on this one. What concerned me, I think, particularly on this one, was that the 3 closest stores that are all within 0.4 of a mile are located on the same street, and the closest store is a license that was issued less than 2 years ago. So that's my initial.
Yeah, that was my thinking. So I deny based on those reasons.
Yeah, I'll deny it also. We also have a pattern of declining sales for the other than the recent, the 2-year-old license, where the figures are not reliable because you get the first year. So it's tough to compare to as a partial. But with the second and third closest stores, there's a decline in sales, so it's denied.
$250 House of Liquors and Wine. The number.
Good morning.
Morning.
Sylvia Matrina Nunez, attorney appearing on behalf of the applicant, House of Liquors and Wines.
Protests?
Yep. Step up. William?
I'm the owner of Midway, one of the owners of Midway Wine and Liquors.
Okay, we'll hear you. Go ahead.
I'm here to oppose this. 3 reasons. There's a high density of stores already in the area. I believe we're 0.4 of a mile away from the store. And I think there's 3 other stores very close by to us as well. Zacky's is only 3/4 of a mile away. That's, so I feel the area is adequately served. We are a fairly new licensee. And, I feel we haven't been given a chance yet. And
Did you respond to, we sent you a letter asking what, for your sales?
Yeah, I sent the.
I'm sorry? We haven't? I'm sorry.
No problem.
You're also way bigger than the applicant. You're 10,000 square feet.
Yes, yes. We are a fairly new licensee, though, and we haven't been given a chance yet to succeed yet, and don't feel it's fair to have a new store come in the area. We're still in our ramp-up period, and our revenues, you can see from 2013 and to early 2014, are still flat. We are working very hard on growing and being able to survive, and any competition for us at this point would be,
All right.
would be tough.
Thank you.
Thank you.
Is your client here today?
No, unfortunately, my client was not able to appear. He's currently a daycare provider and didn't have an alternate that could stay at the daycare today. If the board would like him to appear, I would have to request.
When you say he's a daycare provider, he works at a daycare?
Yes.
He owns the daycare, or he works at the daycare?
He owns, well, he's currently registered as the daycare provider. If he owns the daycare center.
He owns the daycare center. So that's his full-time occupation currently?
It is.
And does he plan on leaving that if he gets
He
approved?
does.
He does? I mean, how do you address that within 1.1 miles, there's currently 21,000 plus square foot of alcohol available for sale to the residents in that area, and that aside from, I believe, the two larger ones and a new issuance of October 2013 for Central Warehouse Wine and Liquor, that the other two are having significant decline in sales. How would you address those two concerns?
The area in which the applicant's location is located is Central Avenue, which is a pretty major thoroughfare that runs from Yonkers up to White Plains. There's very business-heavy oriented, all of Central Avenue. Most of it is commercial, shopping, strip malls, business buildings, where it's a very high-trafficked area, where although if the lights are all in your favor, it could be a quick trip down Central Avenue. It could potentially take 15 minutes to go a quarter of a mile on Central Avenue, depending on the day. So my understanding is also that one of the stores in the vicinity, I don't know exactly which one, but one of them is closing. So I don't necessarily think that the applicant opening the store that's before the board, it's a much smaller store, for example, than the gentleman that was just up here. It's only 1,560 square feet. It's a corner property located where there's very residential on the two side streets that go behind it, which it would provide walking distance for people who live in that direct neighborhood instead of having to get in their car and driving. There's a couple of restaurants, there's car dealerships, there's several businesses located right there, and I think that this would serve the community.
Do you know which, you said you don't know which one is closing, but in fact, that's actually a very important piece.
I could get that information and provide it to the board. I heard that a liquor store was closing, but I do not have the information specifically as to which one.
I think the only one that really would affect or factor into my decision is if it's Scarsdale Wines or maybe Central Warehouse.
Yeah,
Those are the two.
We know it's not Midway.
And I don't think it's Zacky's either.
No, I don't think it's Zacky's.
I believe it's one of the stores directly on Central Avenue.
Well,
that would be then.
Is there a big divide in the middle of Central Avenue going one way and on the other side of the road?
It's 2 lanes going in either direction.
2 lanes going in either.
I mean, there's a median.
There is a median?
But there's, well, some blocks, depending on which neighborhood you're in, Scarsdale, Hartsdale, sorry. But there is crossover because they're shopping,
Sure.
I said, on both sides.
I mean, Midway and Central are, based on the addresses, I assume, on the other side of the street? Is that
Yes,
correct?
that's correct.
Midway's on the other side of this proposed location?
West side of the street?
Are you going north or south? South.
South, yeah.
Yes, they're on the opposite side of the street. So where the traffic is going northbound, the other 2 stores are located on the southbound side.
And this parking lot
There's
yeah.
a small parking lot directly behind the retail space.
exclusively for them, or it's just shared?
The spots directly behind their store are exclusively for them. And there's metered parking all along Central Avenue.
Okay, at 12?
Well, I mean, for me, it's hard because 22,000 square feet of alcohol being sold in that 1.1 mile radius, I guess, and looking at the declining sales, if Scarsdale Wines or Central Warehouse Wines were the one of the 2 stores that you mentioned might be going out of business, that would impact my decision. But currently, based on these facts, I vote to deny.
Yeah, and we do have a letter in opposition from Central Warehouse Wine and Liquor. So I assume they're around.
Would you permit me 48 hours to provide you with the information as to which store is closing and reserve your decision until that time?
Yeah, I would do that.
I'll put it over after the next meeting.
Sure.
All right, thank you very much.
All right, so that would be
224?
224.
Thank you.
Okay. I need to ask for a recess now. You call. We're going to have a short recess.
Next item. Thank you. All right, next item is 266G. Anna Salazar, I believe we have an interpreter here for her.
Good afternoon. Elias Sage on behalf of Ms. Salazar.
Good afternoon.
Good afternoon.
We made a request for reconsideration for the board to accept the $1,000 penalty instead of the $6,000 that was imposed.
I'm sorry, could you speak into the mic a little bit?
Hello? We're requesting a $1,000 penalty instead of the $6,000 that was imposed on October 21st.
What's the basis of that argument?
Ms. Salazar had all the proper permits, however, she just had them behind the bar instead of posted as she was supposed to. She has recently posted all the permits on the wall. With relation to the business name, El Congrejo, she was under the assumption she was operating under the parameters of the license. She's had a gentleman help her with her applications and renewals. I spoke to him. He indicated to me that he would take care of it. He thought it was in compliance. He finally gave me a call last week indicating that, oh, he's in Florida, he can't do it because he's been living there. So I've received help and the guidance from the secretary, and we'll be filing the proper paperwork for the DBA. She does have a business certificate under El Congrejo from 2005 when she first opened the premises. However, she never filed the proper paperwork with the board because she was unaware, because she had this gentleman who was helping her file the proper paperwork.
And what about the gambling?
The devices that were in the premises were not gambling devices. Actually, they were given back to her by the police department of Yonkers. She did not plead to any criminal dispositions regarding that matter in Yonkers. She did plead to a disorderly conduct. Again, the machines were not gambling devices. She's not going to have those machines in her premises at all anymore. She understands the importance of not putting the illusion of any kind of gambling in her premises. She's taken them out of her premises, and she's a hardworking woman who hasn't had much contact with the board or the criminal justice system, and it's very difficult for her to pay the $6,000 fine. We're just asking for $1,000.
I mean, based on the charges, most of them are failure to post warning signs, the unauthorized trade name.
And I will note she did have all the proper permits. She just had them behind the bar, not displayed as she should have.
And the dancing?
She has a cabaret license also.
Oh, she does? Okay. All right. I'll agree to $1,000.
I'll do it also.
Thank you.
But make sure she gets that paperwork in.
I will
Because
help
or else someone will be out there and it'll be another violation.
Understood. I'm going to guide her through that now.
All right,
Thank
thanks.
you.
Recalling 218 Liberty Palace and Banquet Hall.
Yep.
Yes.
Has your client decided whether or not he can operate with a 1 o'clock closing?
Well, yes. At this time, I did discuss the timing with my client here. Although it is going to be very hard, it will impact our business negatively. We don't have no choice. We will accept that timing you give me, and I'll try after a little time to make a request to increase the hours.
Okay, you've got to wait at least a year. We're not going to entertain a request 6 months after. But after a year, you can file to come back with no promise, but you can make the application.
Yes, we always work with the police department, everything. We wholly went with the police department. They're aware of our timing and everything. And
Okay.
we always comply with all the rules and regulations,
All
with
right.
the health department, everything.
So it'll be 1 o'clock on the license. Thank you.
All right, thank you.
Did you say 1 year with leave and 1 year to come back? Or
They
two?
can come back and they have to wait at least a year to come back.
1 year, okay. 251 Tattoo LLC.
Good afternoon, Ravi Sharma here for Tattoo LLC. With me is Ilhan Ursahin, who is the sole principal of the LLC.
All right. Based on the paperwork, I think I'm ready to vote. Let's see if you want to ask any contracts.
Do we have anybody in opposition? Community Board 3 is not here.
The community board is stating that they did not change their position. Susan Setzer, I thought I quoted the email.
You see that?
They're not changing their position.
The position is that they're not opposing.
They're not opposing.
Yeah, there have been some issues about noise, but you've submitted some documentation in the last few days indicating that your client has been very aggressive in dealing with those complaints. So we've actually got something that you sent us from somebody who had complained, who says that he really has made a very substantial effort. So I'm ready.
Yeah, I mean, based on the fact that Community Board 3 doesn't oppose, I approve.
Yeah, I approve it too.
Thank you very much.
Good luck.
214 Ray DiPolo.
Good morning, Mr. Chairman. Final compliment on behalf of the licensee. This is an application to extend hours not late into the night, but earlier. My client has been...
That was the issue here, as you'll recall, and there was a daycare center across the street.
Correct.
And we do have opposition from the daycare center now saying that, now you're getting close to operating hours.
Getting close to operating hours?
Of the daycare center.
Well, it's during the day, Monday to Thursday, Monday to Friday. And the real issue here is, first, there's a statute. The statute talks about schools, churches, synagogues, places of worship. 200 feet. Liquor. This is a restaurant, wine and beer. There happens to be a church around the corner. In fact, I spoke with them myself.
I don't care about the church, but the issue, people came in here and they said what their concerns were, and they seemed reasonable enough to us that we imposed these restrictions, and your client agreed to them. So it's not like this is a brand new issue, and you can't tell us now that it's irrelevant that there's a daycare center there, because these hours were originally agreed to because the daycare center was there.
You did say we can come back.
Yeah.
Which we did because there was a discrepancy in 1 hour. There was a discrepancy, and you granted
Yes,
that.
and we did do that for you.
You did say
Right.
initially that we can come back.
And I'm willing to
and
talk
ask
to you,
for-
but don't tell me about churches.
Okay.
We know what the issue is here, so let's just get to the issue.
Okay. I have the letter from the Executive Director, February 5th, 2015. She states that there has been no alcohol-related activity, such as persons urinating in the street, persons stumbling out of their establishment, broken bottles, and other debris. That's true. Not only that, but that's true all the time that my client is in business in regular hours, late at night, Saturdays, Sundays. He has run a very good location, 3.5 years, if I'm correct, September 2011 till now. He has been, especially during the day, Monday to Friday, but also on weekends. There have been no problems at all regarding those issues that they were worried about.
Can I see the letter, please? Oh, it's the same letter we have. It does say they're in opposition, but it just does say that there have been no alcohol-related
There
activity.
have been no incidents.
Yeah, we have this.
Okay.
But she does say the current hourly restrictions for the serving of alcohol has worked well for a safe, clean, and quiet neighborhood for the young children that we serve. Do you know what time, how late they're open? I remember we bumped it down to 5:30 because we felt it wouldn't conflict with the kids going in and out. Do you know what the hours are
As
there?
far as we know, it's about the same, about 5:30. My client is being harmed financially. He cannot have business meetings during the week. Businesses do not have meetings on the weekends. They don't come because there is no sale of wine or beer. So they book someplace else.
When does he open?
When does he open? He opens at 11 o'clock in the morning. Oh, I think, what time do you open?
About 10 to, sometimes to 12, sometimes to 4.
Okay.
I'm sorry? So what time is he open?
10 o'clock in the morning.
All right, so the business meeting, what are you talking about, lunches?
Lunches, sure.
So when do you close? You close in the afternoon for a few hours or no? Oh, so it starts at 10 and goes till 4 a.m.?
Only way to sell food and soda or natural drink.
And only sell food, so he can't book.
Well,
The same
I mean,
people, what's interesting is the same people who bring their children to this daycare center come to his place because it's one of the best places in all of Spring Valley. As a restaurant, they bring them there, they sit down, they order a beer on the weekends or in the evening, and the children are sitting at the tables with their
Well,
parents.
I'm open to allowing for lunch hour service, but maybe when the kids are coming in and out, it's not being continually served from. So, for example, I think 11 to 2, there could be service, but after 2, you don't serve until 5:30. That's my proposal. I don't know what the chairman.
That makes sense. If you're talking about business lunches where somebody wants to have a glass of wine, they're not going out at 3 or 4. And I think one of the things we're concerned about is the person who comes in at 3 or 4 in the afternoon just to have a few drinks, and then they stumble out and the kids are right across the street. So I would go with that. And that would solve the problem as you've described it.
You understand? I understand. I can't have any choice? Any other choice?
We're not, the question isn't do you have a choice. The question is your lawyer has articulated why you need this. And he said the biggest reason is people have business meetings. They have lunch out. They don't go out for lunch at 3 or 4 o'clock. So it would seem that Commissioner Kim's suggestion solves your problem. So people aren't eating. We want to know at least that maybe there's a good chance somebody's having some food with their alcohol. 4 or 5 o'clock, I get a little worried about that. 12, 1 o'clock, at least somebody's having some food probably if they're coming in. So it makes us feel that it's less of a dangerous situation. Now, tell me why not being able to serve, say, at 3:30, serve alcohol is a problem, would be a problem for you. What's the audience that you're targeting at that particular time?
Because sometimes we have a customer, they go play food and stay there. But we have no problem, with these people across the street.
That's what worries me. If it's a pool hall from 3 to 5:30, then I'm a little concerned about the alcohol. But I think Commissioner Kim's suggestion is a very, very good solution, and because it addresses our concerns about public safety. Mr. Koppelman, when you applied, we didn't talk about a pool hall. We talked about a restaurant. So that was what gave us some comfort.
He's got a pool table.
Yeah.
I mean, it's
But
a
when people
very
put-
large place with high rent. He has a
When
occupancy
people
of
play
100%,
pool-
but he only fills up 60, 70 people at
Well,
best.
when people play pool, they tend to be drinking. They don't tend to, have a salad while they're playing pool. So we'd feel a little more comfortable, I think, with that, and yet we're addressing your issues.
Is the bulk of your business between 2 and 5 serving? I mean, people playing pool. That's kind of the target audience.
When we have a rain day, people don't work, they go to pool, and we wish to have a choice to sell the beer, because it's part of the business, but if I don't have chance, it's fine. It's fine for me.
Let's start here.
If we give you this, you've whittled away pretty good at what we started with, and maybe you come back in another year or two.
Maybe.
All right. So
If I'm still around.
So let's do
11
that.
to 2.
And at 5:30 to closing. All right, 11 to 2 and 5:30 to
2 and
closing.
11 to 3, you said. Which one was it?
11 to 2.
11 to 2.
Okay.
Yes.
I'm getting a little old. I
Yeah,
can't
it
remember well.
doesn't. All right, he earned it, whatever you're paying him, he earned it today.
Thank you.
236, YS Wine and Liquor.
Good morning, gentlemen.
Good morning.
Russell Guba, representing the licensee. Licensee was served with a violation for sale to a minor and engaged the services of the Korean American Small Business Services because of the ease of language, native language. Mr. Kim of that organization is here today, and he can better explain what happened with respect to resolution of the violation. Suffice it to say, he was under the impression that there would be a civil penalty of $12,000, which he offered. My purpose in being here is to represent to the board. She's got a sale of the business pending, which I've been holding for 3 weeks, awaiting the outcome of the board's decision. If the board can see fit to impose a civil penalty of whatever appropriate amount the board feels proper, the sale will go through. Mrs. Lee will no longer make appearances for disciplinary or violations. She'll be out of the liquor business.
Well, I mean, even if we impose the cancel and bond, I don't think that the new purchaser has to come for a new license application anyway. So why is the sale contingent on whether it's a monetary fine or whether it's a cancel and bond?
Application of the license, no sale of the business.
It just shuts him out of the, he doesn't make any money. He's gone, and
Right,
now the guy
right,
just
right,
comes in and does the
right.
deal with the landlord, as opposed to now where he's transferring
Right.
assets.
I mean, these 3 sales, each time they did a violation of the sales, they had notice, correct?
No, he says no. In the memo, it says no.
Don't you get a DAT
Not disputing the violations.
each time?
With the NYPD?
Well, the 5, 9, 6, 21, 8, 4, the first 3 violations, did they get notice?
At least according to the memo from counsel's office, he says the licensee did not receive notice until the 3rd sale had occurred.
But that's notice from us, don't they get?
Oh, no. That's how the PD does it, because they say for nuisance abatement.
Got it.
Now, there was 1, 2, 3. Yeah, he received after the 3rd sale. So although it was 3 sales on that first
Right.
one, he didn't have notice.
Well, and that's important.
Now I am concerned that the full board fined him in November of 2012. He would have gotten the notice within a few weeks. So let's say he paid it in December of 2012, and then less than 2 years later he gets another violation. But I do think that as I think we've discussed before, that's why the 3 sales would have been 8,500,
Right.
which is low because of the one notification.
Right.
So I'd suggest a little more than the 12, perhaps, maybe 15, but I'm willing to fine them.
All right, I mean, based on that notice issue, I thought he had notice each time, and if this were the 4th, it'd be a clear cancel and bond for me. That was his first notice, and those 3 were lumped together, and he paid the fine. I'll do $15,000.
Yeah, so we'll counter if he pays. We're not taking his offer of $12,000, but if he agrees to $15,000, then we'll take that.
That's good.
Okay. All right.
Thank you very much.
You're welcome. Yep.
262, Beautiful Paradise Restaurant. Who do you have?
Good afternoon, Chair and Board. My name is Anthony
On my list.
Torres, and I'm here for
he's over here.
Beautiful
He's next.
Paradise
Sorry.
Restaurant Corp. We're requesting that you approve this application if there isn't any community or board opposition.
Is your client here today?
No, he could not make it. He didn't give me details as to why. So, but
Because I'm concerned, because we've got a we've got a location where the license was revoked because of serious problems. Your client has no experience in the industry. And in addition to that, I look at the menu, and I don't see why you need a full liquor license given this menu, where the typical item is maybe $3. You know, a ham and cheese. You don't need to have a cocktail with your ham and cheese sandwich.
There is some other items there that are a little bit more. I mean, this is not an area of where there's high exclusive people coming in to eat. It is in a neighborhood which is low income, so he's trying to provide for that in his prices.
But there's no chef. There's the question of will you...
Oh, there's going to be a chef, yes. There's somebody.
That's not what you indicated. It says, does the premise have a kitchen? Yes. Is a chef/cook employed at the premises? No.
Well, that could be amended if you give me the chance to do that.
What are his proposed hours?
His hours are from 9 to 2 during the week, and if possible...
9 p.m. to 2 a.m.?
To 2 a.m., yes. And if possible, on the weekend until 4. And if your board is not in agreement with that, we're willing to consider other hours.
So it's a restaurant, but they open at 9 p.m.?
Yes. No, 9 a.m.
Oh, okay.
9 a.m.
To 2 a.m.
To 2 a.m., yes.
9 a.m.?
Yes.
So what is it he's serving at 9 a.m. off of this menu? Tell me what people are going to be ordering at 9 a.m.
Well, you know, the area has a lot of taxi cab drivers. They're rolling around different hours. Some don't eat breakfast.
All right, so just tell me what are they going to order at 9 a.m.?
Well, you have a ham and cheese. You have a beef. I mean, there's things here that people would eat on breakfast
at 9 a.m.
Yeah, I mean that's what he has. He can amend the menu. I mean, he has.
I'm not asking him to amend anything. I'm just asking questions about how he's going to operate with a full liquor license.
Yeah, he. You know, you're right. This is a new business person trying to open up an establishment for the first time. He can amend this menu to reflect a breakfast serving, but this is what he gave us at the time. You know.
And where did you say your client was today?
He didn't indicate. He just said he couldn't make it, and could I please show up for him?
What does your client do?
He used to be a sales person. And he manages sales.
What did he sell? I saw on the application sales representative. Do you know what he sold?
No, I don't know, to be honest. Yeah.
Because it says self-employed. He didn't list an employer.
Yeah, I have no idea what he sold.
I'm willing to give this a look if he comes in next time.
Yeah.
But I think it is a problematic location. Mm-hmm. I've got serious concerns about why it needs a full license as opposed maybe to beer and wine. So if you can produce him at the next hearing date, we'll talk to him.
Okay. All right. So just have him come to the next. Thank you very much.
So that would be the 24th.
The 24th. Thank you.
231, El Monte Entertainment. Sir.
Good afternoon, John Springer for the applicant, who is with me, Elvis Almonte. I didn't prepare the application, so everything I know comes from the agenda sheet, the revocation order for the last license, and what Mr. Almonte's told me. We are aware of the past problems of the previous licensee. The place has been closed for over a year. Apparently they were operating as a bar and were kind of rowdy and had dancing. Looks like there was at least one fight. This gentleman...
I'm sorry, so you didn't prepare the application. When were you retained in this matter?
When it was put on the agenda?
When it was put on the agenda last week?
Yes. I don't know how he found me, but he decided to have somebody come speak for him with him today. He met with Community Board 3. Apparently, they voted to recommend approval of the application. I don't know if they submitted anything.
They didn't. Do you have anything?
I don't.
How do we know they did vote to approve it?
Based on what he told me at the,
Can you step to the mic, please, and let us know how you know that they approved?
I went personally, and they approved, and we should have the paperwork.
You went to the full board hearing or just the committee hearing?
The full board.
And they said yes?
Yes.
All right.
We voted yes. I was there.
Mm-hmm.
presumably there was notice, and Community Board 3, I know, is very good about letting their feelings be known.
And you have no prior relationship with the previous licensee, currently or in the past? You don't know him or her?
I met him.
You met him?
He indicated to me that he had he's from the neighborhood, he had been into the place, he knew the owner from just being there. He had heard while the place was still open, it's been closed for over a year, that they were losing their lease. He wasn't aware until I told him, and until I found out the license history that the last license had been canceled. He thought they just had lost their lease. He knows the landlord, and he went to the landlord and said, I'd like a shot at this place. There'll be a Latin American fair, no live music, no dancing for employees. He's going to manage himself.
Why not an RW? It's a Spanish restaurant, it's not a nightclub.
He indicated there were several new hotels that have been coming up in the area, and why local instead of just one beer?
Well, it's a modern land cuisine, and it's a very strong place, and we have several hotels nearby. The Guardia is 10 minutes away.
So you think that the people who stay in the hotels from LaGuardia go to the local restaurants in Corona?
Yes. I'm in Northern Boulevard. There's 3 new hotels right there. One block away and 3 blocks away.
But how far is it from LaGuardia? A mile or two at most? Short cab ride, right?
Yeah, 10 minutes away. It's right.
If we issue this license, I'm just telling you now, we get a lot of complaints from the community, from elected officials, about the kind of violations that the last licensee had, like unlicensed cabaret. Get very consistent complaints from this area. So I'm just telling you, if you invest money in this, because we give you a license, and you commit those violations, we are going to shut you down, because the community there can be very aggressive when there are problems like that. And the problems that the prior licensee had were typical of what we've been hearing from that community. And you can be opening up at that location. A lot of the same people may come back, and if they were dancing there before, they're going to expect to dance now. And putting a sign up that says no dancing isn't going to get you off the hook. If they're dancing, that's going to be a serious violation, and some of the other things that have gone on there. You understand
No
that?
dancing, no.
And noise. Noise is another issue.
It can't be off the music.
And you said the chef's going to be there from 9 to midnight? But you're staying open till 4?
The chef?
I don't know. Here it says on the questionnaire you have a chef or a cook.
There has to be a chef present, always.
So you're closing at midnight?
No.
Well, the chef's only going to be there till midnight.
No.
According to the application.
According to your application.
He's saying that was submitted in there that way.
All right, so the chef,
No, it has to be there.
so the chef will be there all the time when you're open?
Yes.
All right, can we put that on the license? All right, so that'll be a condition of the license, that the chef is always present.
Okay, I'll approve with those conditions.
I will too. Good luck.
Thank you.
$235, 3108 Loft Cafe.
I had a grant for this.
Good afternoon. I did too.
Yeah, we'll grant the reconsideration.
Sorry?
We'll grant it. We'll grant the
Very much.
reconsideration.
Yes.
Very much.
Thank you.
$263, The Whiny Husband.
Hi, good afternoon. I'm here to represent myself.
Okay. Do we have any opposition? If there is, step up, please. We had a protest submitted, but I guess no one's here. Go ahead. Let me tell you what my concern is, and so that you can maybe tailor your remarks to address it. We've got of the 4 closest stores, 3 of them are also on Washington Avenue, and they're very close. There's one, just 1/10 of a mile away. So I would be very reluctant to approve this. But go ahead.
Okay. Well, as far as we know, right now there's over 6 new condos, new developments going up, and there's about 100 new units. That's going to be up within a year to 2 years. And we're a really small store. We're only about 500 square feet, and we don't have extra additional storage for our wine and liquor. So we wouldn't really be a huge competition for the other stores.
What's your proposed mix of alcohol to wine?
Maybe 10 to 20% of, that would take up the spaces like this.
Yeah, so 10 to 20% would be the hard liquor, the alcohol, and
I mean max, because on 500 square feet, that's including, our storage and our bathroom and everything,
So what is your shelf space? What square footage is the actual sales floor?
About
350.
350, and you're saying 10 to 20% will be liquor?
It's
really
since
small,
we are so small, we have to kind of navigate certain things. We're constantly moving our space around, so it might be behind the counter, and then we have to find maybe a little bit more room.
So what is it? What spirits do you intend to sell? It's going to be. You're arguing there will be a very de minimis amount. So what are you going to have?
So small batches, local productions. Brooklyn-made spirits, because it's very popular, and those are things that the other liquor stores don't carry right now.
Yeah, sure.
Yeah.
Or state your name for the.
My name is Kenneth Hong. I'm the winey husband. The difference between
Congratulations.
behind every successful woman there's a winey husband. She runs the store. Like the difference between our products is different because the other 3 liquor store, they're bulletproof glass liquor store, and they carry Yellowtail and Gator Negro and all those stuff, and we don't carry those stuff.
The other 3 meaning the 6 Arena Wine, Grand Plaza, and Wine Love Liquor. Those 3.
Yes.
The ones on Washington Avenue.
And
you guys are not bulletproof.
We're not bulletproof. We're open space. We're so small we can't really have it bulletproof. And also, when you walk by, you see huge poster of Wolf de Clos and Maurice Chardon. We don't sell those products at all. We sell really small productions, like small French, Bordeaux wine. And
So in terms of the liquor, you said you'd sell liquor that the others don't sell. Like what? You said some Brooklyn distilleries.
Distillery, and then there's some whiskey, Hudson whiskey.
There's a Rico,
So New York State liquor. Will you be selling Johnny Walker?
We honestly can't compete with them because we do know they carry it, and we don't have the space to buy big, pallets of whiskey like they do. So.
And our clientele is also the neighborhood is changing a lot, and our clientele really want smaller productions, a lot of organic also. So I hope that you grant us the license.
I mean, part of the argument from the protesters was that you guys are doing fine as a wine store. Why do you need to add this liquor component? And if you're representing that you're going to serve maximum 20%, and they're all going to be New York State distilleries that the other 3 on Washington Avenue do not have, then I could see that serving public convenience and advantage.
Are you saying you are representing that any spirits you sell will be essentially small batch spirits?
Small batch, yeah.
Okay, and that's 100% of what you're going to sell in terms of spirits. All right.
Definitely no.
Okay.
Yeah. No
Can we get that on the license? And I'd be okay with that. I'd prove that. New York State small batch.
Or small batch like bourbon, not only New York State, but
not only New York State on the
I would
bourbon,
say
small
New York
batch.
State slash small
batch.
Yeah.
Okay.
All right. Approved.
Thank you so much.
Good luck.
Thank you.
Yep.
Right.
219, 4 Happy Men.
Good
afternoon, Chairman and Commissioners, Deputy Commissioner and Council. I represent 4 Happy Men in this application for an on-premise liquor license for a restaurant.
I only see 2 of them here.
There are more.
Just making sure.
There are more. And there's also some residents and supporters here as well for an application for a restaurant at 91 South 6th Street. And I'll let them introduce themselves and explain a little bit more about their concept. The application is here essentially because the Block Association opposed, and it's really related to the hours. The Block Association in that area is currently recommending that everybody close at 11 on weekdays and midnight on weekends. And those were not hours that my clients could agree to at the community board meeting. This is a previously licensed establishment with no restrictions, a location that did offer late night dining. It's under 74 seats. It's in a commercial district. It's not a heavily residential neighborhood. There are about 10 licensees nearby, 9 of which have no restrictions. It's not an area, none of the licensees nor the prior licensee here had any negative adverse history. The applicant has obtained over 100 signatures of support from within a 3-block radius. The landlords here can describe a little bit more about the nature of the neighborhood, that can attest that it's commercial. And the applicant requests that this license be approved without restrictions. And in this instance, given the nature of the business, the location, the fact that it was previously licensed, and that none of the applicants in that area have had any noise complaints or adverse licensing history, the applicant submits that there's no reason to curtail the hours of operation as requested by the Block Association.
Just 1 or 2 questions about the principles. In the business plan, Mr. Del Rio is described as operating a real estate and hospitality firm.
Yes.
How is it, on your questionnaire for us, it indicates you're a real estate broker. What's the hospitality end of that?
So for the most part, I work with hotel developers, and I consult on what kind of operators and brands they should align their development project with.
I didn't understand.
So a hotel developer. So let's say
you're a real estate broker, right?
Real estate, not so much a real estate broker. I work more on.
Are you a real estate broker?
Are you a licensed real estate?
I'm a licensed real estate broker.
Okay.
But my job with the hotel developers, for the most part, is pairing them with the right operators for their space, given their property in a certain demographic market.
You're a consultant on top of being a real estate broker, and that's where your hospitality.
Exactly.
All right.
Real estate brokers can be very nice.
And we have the chef here as well, who's been on Chopped, won Chopped, went on to Chopped Champions.
Right.
Our mixologist is also number 2 in the world right now. Amazing cocktail guy.
Number 2 in the world. There's a ranking for mixologists.
I know. Yeah, I learned that myself.
It's competition.
My concern is we're starting to get a lot of complaints from the Williamsburg area about too many late night bars. So how do you address that?
One of those areas that is heavily oversaturated. If you take a look at, I think, the maps that were submitted, this is not on Bedford Avenue, this is not near Bedford Avenue, this is South 6th Street.
I can do this. My name's Rich Pagaston. I represent the owner of the building, and we also own approximately half of the entire block, at least that side of the block. This is a street immediately adjacent to the foot of the Williamsburg Bridge on the south side. The quieter side, I guess you'd call it, it's the only street between the actual bridge, the big cement wall that goes up 50 feet,
I know it.
and Broadway. So basically everything on this side of the street backs up onto the bridge. So the noise is immaterial for anything behind us.
But I think I saw that there are residences on top of the restaurant.
They're my buildings. There are 2 floors over the bar, and they were on top of the predecessor, who had been there over 15 years. So
do you have support from them, or who lives there?
Plus they were over the exact same concept, or a bar restaurant for the last at least 15 years. So there's no change to their life. In fact, this is an easier use to handle. The prior tenant was a barbecue place, and the fumes were quite barbecuing. Whereas this is going to be a normal restaurant with substantially less effervescence. Additionally, across from us, there's only one row of buildings, and then you have Broadway, which is, effectively a 6-lane street, if you count the parking and then 2 lanes of traffic in each direction. So really, there's a handful of buildings, of which most of them are commercial, on the entire street for a block or two in either direction that can be affected by this. And again, most importantly, it's over 15 years that they had the exact same type of restaurant bar in that very building, in that very location.
Do we have protesters here today? Oh, maybe we should hear from them.
Chairman Rosen and the board members, my name is David Heimlich. I live on South 8th Street. This restaurant is on South 6th. We have a block association called Lower Broadway Block Association. My partner Trev was here last meeting about 146 Broadway. We spoke about other issues. We have that particular bar. Regarding this particular application, first of all, about our association in short, saying that this is mainly a commercial area, it happens to be not true. There is apartments being sold for $1 million to $3 million. The Gretsch Building, 26 Broadway, 53 Broadway, and many, many more over the entire block. If you Google it, you see it. You don't see commercial buildings. You see high-end residential buildings paying $25,000 to $30,000 a year taxes. This is a very well-known residential neighborhood with a lot of families and professionals living there. We have the vice president of Sony living very close to it, and many others.
Where exactly does the vice president of Sony live?
He's the president of 60 Broadway, the Gretsch Building. It's right across a block away from South 6th. The entrance to South 6th has to come from Broadway, so it's not just an isolated block. There's no way to get to the South 6th, only through Broadway. So obviously, any traffic or noise what's happening is going to go through Broadway. As far as, so basically what we have done is we sit down with every single application. They mentioned 10 bars. There's not 10 bars. There's about 6 or 7. But we sat down and discussed with every single, and we worked at hours, all of them. All of them are closing by 11, weekdays, 12 o'clock the weekends, and they're cooperating. There's actually a 500-foot hearing next Thursday about Mountain View, Mountaintop, and they are opening on Donald Place, also a very small little street on South 6th. They are working with us. They're closing 11:30 on the weekdays, 12:30 on the weekends. And so is 53 Broadway, and so is 25 Broadway, and so is many, many more that the last year or two they are opening. They're working with our hours. And basically what we want is very simple. We want to have at one point be able to continue life, be prepared for the next day, and not having noise and vomiting that happens to be on that particular site, a Fericure, that was open for 15 years. Yes, at that time nobody lived around there. But once people start living around there, it became a problem. People are complaining still for those that are open for late of the noise, vomiting, and all of this stuff going around. And I happen to tell Mr. Pogosti, and I respect him very well, but he is the landlord for TBA, 395 White Avenue, and that is a liquor license that got denied the reapproval by Community Board 1 and was shut down by the building department 2 months ago, running without sprinklers and proper permits. So this is the kind that we're not trying to avoid. We're trying to have a family-oriented restaurant, the same like on South 6, and many others were planning to open on that street. It works for the community. That's what 500 Food is all about, public interest. This particular, being open to 4 o'clock, is no public interest at all for the entire block and neighborhood. If somebody wants to have 4 o'clock opening, let them go to North 6 and North 12, where all the bars are. But this particular one is a residential neighborhood, and we're really asking the board to obviously, we are prisoner friendly, we're welcoming them, we would love to see them in our place, but no way in the world we're going to accept to be open to 4 o'clock.
All right. Ms. Hoffman, this is a 500-foot case, so that's a significant concern to me, at least, if I've got the community board and a local organization opposing it.
This particular location, it was not an asset transfer, so it's not technically a transfer, but this is a location that has been licensed for a significant amount of time, and in fact did offer late night dining. And because it's a 500-foot issue, they obtained a lot of signatures, and so there are additional residents here to support them as well, to demonstrate that there is a need for late night dining in the area. The other bars are open, there's not much food being served late. They have their chef here, and I think they're prepared to demonstrate that, in fact, it is still in the public interest, even though there are now more than 3 establishments within 500 feet. So, I mean, there is a resident here from the building in the immediate area. Like I said, over 100 signatures from within 3 blocks. The Block Association is a large territory. 175. Over 175. Well, 175 till over 100 were within 3 blocks. I think so. I think they've gone out of their way to obtain evidence that it's in the public interest. So they're still.
And those 100 were residents or businesses?
Residents.
All residents?
All residents.
Did the opposition submit signatures?
No, the Block Association, as a blanket rule, it covers a large territory, including areas that are more residential, and has, as a blanket policy, started to request these limitations on hours.
Just to be clear, Mr. Heimlich is a local real estate broker. He's contacted me at least 2 times since this started to put in his own tenants. In other words, he wants commission. So, you know, the block issue may be true or not, I don't know. But I do know that, you know, he certainly was standing online quickly to get his commercial tenant in that building for permission.
As opposed to you, who have no interest in this.
Of course I have interest, but, you know, the answer is, and I do have 3 of the bars are my tenants in that area, and none of them have.
What else is on that street commercially?
A gym, an office building, right immediately next door is a small little, what do you call it, a chocolate shop. Next to that is a bar. Next to that is a bicycle shop.
How late is the bar open that's there?
No limitation that I know of.
All right, so there is a bar there for residents to go to.
Not food service.
Yeah, they have no food service. And across from that is the back, across the street is the back of, I guess, 4-story residential buildings with commercial on the first floor. But those, you know, they are really they open up onto Broadway because it's a half there. At the end of the block is a lot. Down next to us, immediately next to us is 2 abandoned buildings with squatters in it, and next to that are 3 commercial buildings to the corner. So it's really, you know, within 100 feet. The only real commercial residential is across the street. Those buildings that are on Broadway. Like I said, there's 2 apartments on top of my building, and then on top of the other bar, which is also ours, is 2 more tenants. And other than that, the bike store is no residential. Next to him is no residential. And then you've got, you know, 4 buildings to the other side of us who have maybe 2 legal tenants. Immediately next to us is at least 40 foot of abandoned building. May or may not have squatters in it. Something's going on there. I don't know.
And beyond that, we have the neighbor from upstairs. We have a long-term tenant who's been a neighbor for 15 years. Justified to the neighborhood and he was strong supporter of.
Good afternoon, ladies and gentlemen. My name is Nicholas Wheely, and I'm in support of this project for sure.
I'm sorry, I didn't hear. Where do you live?
I live on Dunham Place. I live a block and a half from the proposed site. And right now, yes, there are other establishments around, but there's no place that you can get quality food at night. There's, aside from delivery, that's about it. There's no place that serves food that's, you know, past 10 o'clock. So it's a nice...
And you have, obviously, you have no connection with this application,
No,
correct?
no, just through the neighborhood. And I like the notion of something new coming in. As he was saying about Fatty Q earlier, that Fatty Q was not there for 15 years. I mean, maybe 5 years at most. And yes, I could smell them smoking all the time when my windows were open in the summertime, which was annoying. And they were open a little bit later, but their new project has nothing to do with the Fatty Q. So at any rate, I'm in support of their project, and as well as other people that are in the immediate neighborhood that I've spoken with about the project.
And what do you do for a living?
I'm a builder.
You're a builder?
Yes.
What do you build?
I do residential, mostly residential. I do renovations, and I do a lot of farm work upstate.
So you do a lot of work in the neighborhood?
So sometimes, but mostly I've been traveling for work, usually California and then upstate New York, on just facilitating homesteading for farms and such. So at any rate, I work alternate hours, so it'd be very nice to have something that's open late night on a quality notion.
When you say alternate hours, what do you mean?
As opposed to closing at 9 o'clock at night for food. So the kitchen wouldn't stay open later, and you could also get a beverage.
I mean, what's an example of you working?
Oh, I say I would be done. I'd work from, say, 1 in the afternoon until 9 or 10 in the evening, just based on that's how the hours go sometimes. It's not 9 to 5.
Yeah. So you would eat dinner at 9 o'clock?
9 o'clock, yes.
Do you eat dinner at 3 in the morning?
Not that late, but I mean, I would eat at midnight for sure.
Yeah. Okay.
Yes.
All right.
Thank you.
Yep.
If you don't mind, Your Honor, there is restaurants open till late night. There's the diner on the corner of Broadway and...
I think you would have to say there's probably a difference in the quality of food from a diner and then somebody who's a trained chef.
That I'm not going to go into it, but
Right.
there is where to eat, number one. Number two, some of the signatures, I did speak to people living on that block and asked them, do you know about it? But I said, I signed for it. So why did you sign? They don't want any bars being open till light. I said, I didn't sign to be open. They gave me some very good reception. The food was very good. And I signed the food is good. She did not have, her name is Penelope Cruz. I spoke to her personal. She's a part of our members.
You mean one of these signatures?
Well, yeah, she told me I signed a paper. I haven't seen the signatures, but said I signed that the food is good because that's what they had open showing the food, and I believe they will produce good food.
Would you like to take a look and see who you're talking about? Because, you can go back over there and look at it from your seat, and then when you see somebody. Yes?
Good afternoon. Edward Spector. I live at 91 South 6th Street on the second floor in the building. I'm a long-standing resident of Williamsburg. I've been living there for the past 5 years, and I've been going there for the last 10 years. And living in Brooklyn for the last 22 years. We welcome establishments like For Happy Men because they understand our price point, they understand the quality of the food we're looking for. And as far as the block goes, there's never been an issue of noise or anything of that order.
You used to live above Fatty Q's when it was there? Or,
I still live there now.
Yeah, but you were there when the previous establishment was there.
Yes. And the bridge is the dominant factor here. It's not, it's not the patrons. All right? So that's the underlining point.
All right. All right. I will say that the petition itself, there are some letters that are specific. The petition itself doesn't mention hours. It just says, I'd like to have a restaurant.
We went to the first, so we collected petitions the first time, and we realized that they hadn't done hours. So then they went out and did additional outreach that included letters.
Yeah, the form letters.
Form letters to make sure that it did include the hours and was very clear about the hours of operation. So that's
What time would the restaurant be open? I understand you want to go till 4. When would you open?
Well, the ideal way to operate it would actually be having brunch, I think, on the weekends, so to be able to allow for, an earlier opening. And
so say like 12 o'clock, 11, 12 on the weekends?
11, 12.
And during the week, what time would you open?
During the week, it depends on the actual, demographic and how that is received.
What do you mean?
Because it's a very freelance community, so you have a lot of people over there, entrepreneurs. So we might be able to do lunch, but we are looking to also build out a coffee shop. We're working with the neighbors next door to develop a coffee shop there, and that would be the primary driver to that. For the coffee shop, pastries, something more where people could come, sit with their laptop, and hang out.
For now, if we approve this today, what are you looking for as your opening time during the week?
During the week, I would want to say 11 o'clock. But ideally, the actually during the week, let's say
11 in the morning?
Yes.
Yeah.
Yes.
So you're definitely going to be open for lunch every day?
Yes, yes, yes.
Okay.
Do you see any names you recognize?
All right, are you ready? I don't have any more.
Well, I mean, because it is a 500-foot hearing, the 500-foot law applies here. The one consideration I'm giving is that you have a highly trained chef and the mixologist, second in the world, and no, but I think that does speak to some quality that you're bringing that's a little bit different than other dining options late at night. But I do understand also the community's concern about adding on to the 4 a.m. licenses. Again, you bring up that it was previously licensed to operate until 4 a.m. But at this point, I'd be willing to go only because of the nature of the types of food and the drinks that you'd be serving to offer a 2 o'clock closing. And because I could see people going at around 10:30, 11 for a late night meal in a place like that. But for me, 4 a.m. is too much of a stretch at this time.
Yeah, I'll go along with 2 o'clock too, and if you build up a good track record in a year or two, maybe you come in front of us, no promises, but we might reconsider a later closing. But I would approve with 2 o'clock also.
Would it be possible to do a 2 o'clock on the weekdays and then on the weekends, Friday, Saturday, be open?
No, I think it would be the other way around, actually. If anything, the weekdays, I would have proposed an earlier closing, but again, because of it's in a commercial zone, the nature of the business is there, the support of the residents in the building, I'll give you till 2 a.m. every day, and then we'll see in a year or so.
Well, I guess,
We also consider the physical location. They're jammed right up against the bridge.
You told us that 3 times.
We got it.
Excuse me,
Look, I have a map of
saying
your
it 4
location,
times
okay.
won't help, believe me.
I'd rather have 1 or 2, yeah.
So that's the ruling. Do you want it or not? We're not hearing any more argument.
Would
Do
it
you
be
want it
possible
or
to do
not?
1 and 3?
I'm sorry?
1 and 3.
No, I think
No,
you're not hearing me. The 2 a.m. is the stop.
That's
and
it.
it's not a compromise if you take 1 hour from the weekdays and 1 hour to the. It's
If it
2
doesn't
o'clock.
work, then it doesn't work. But if you want a license, we'll give it to you on the 2 o'clock closing every day.
And because of the 500-foot law, we're being very generous, I think, in this way. Or
The 500-foot
reasonable.
law says that if there are 3 more licenses within 500 feet, we have to listen very carefully to what the community board says. The community board is saying 11 and 12.
No, the block association is saying.
No, but the community board is backing them.
The community board has started to deny any application whenever there's opposition. I think you're going to see.
Well, you can propose whatever rationale you want, but I've got something that says the community board is opposed to this without those hours, and I have a statute that says I'm supposed to listen to them. So, in fact, the gentleman in opposition jumped up and he's all irritated because we're talking about 2 o'clock. So we're not doing this to make anybody happy. We're doing it because it's the right thing. And I just told you I don't want to hear from you again because everybody had a full hearing. And we've got lots of people in this room who've been waiting since 8, 9 o'clock. And you had your chance to say what you needed to say. I need a yes or no from you, nothing else.
Yes.
Okay. So it's issued, it's approved with the 2 o'clock closing. And again, in at least a year, if you've been operating good and the neighbors don't have any problems, you can come back and talk about hours again. No guarantees. But at 2 o'clock and... congratulations, we've made everybody unhappy. Thank you very much.
We seem to be good at that.
Thank you.
223, Tonelli and Associates. Yep.
Okay.
Good afternoon, Mr. Chairman, Commissioner, Council.
I'm okay with this.
Brian.
I just want to know the
Secretary I have
relationship.
with us, Ms. Zeldin.
Can I just ask what the relationship with the prior licensee was?
None.
Have you ever met the person? Do you know the person?
Not personally.
I want to clarify one thing, if I may, Commissioner.
Yes.
In speaking with my client while coming up here, she purchased the machinery from the former owner. And
That's the only relationship she has.
Okay.
That's who she got to employ her, that's right. We also have another employee. And plus,
It's not that far, it's like 30 minutes, 35. I know, I trust her, and she trusts me, and we work well together, so that's why we're doing it.
And I mean, I know it's 6,000, and we only ask for certain limited finances, but you have the finances to be able to run this operation?
Yes,
sir. How do we? I mean, it just looks like 6,000. All right.
what we've been operating, the place has been a grocery store since December when she acquired, when she got the lease from the landlord. So all of 2014, the place has been working. They can do a lot more if they have a beer wine license, obviously.
All right. Okay. I'm okay. I approve.
I do too, but just be careful. This was the site of every violation in the book.
Unfortunately, Mr. Chairman, I learned about that a short time ago.
All right, because sometimes the same kids who used to get served illegally might be coming back to get served illegally, thinking that this is the place where you go. That's all. All right, thank you.
Very much. Thank you.
260, R&J Lounge.
Timothy Allen, which for the applicant.
You need to check, Harry, you need to check on this one, I think.
Yeah, we have it.
Oh.
All right. There's an issue of,
Terry's items.
Is there a relationship with the prior licensee?
There's no relationship.
No relationship?
all right, we were unsure. I'm sorry, go ahead.
Yeah, we went to the community board. Actually, we went several times. We finally met with the full board, and there were no stipulations placed on it, and they gave us their approval.
Yeah, we had something from the community board from November saying that you were withdrawing the application, but our deputy commissioner for licensing reached out to them and. Oh, we had it, okay. We do have something from the community board from January 20th saying that they're in support.
Right, I appeared January 20th, and they voted to approve it.
All right, I approve.
I approve it too.
Thank you.
224, Kings 55 Group.
Virgo Lee, representing Law Officer Winnie Mock, who is the attorney of record. She had a court appearance in Brooklyn, so she couldn't make it. I have her letter of authorization, and we're here to represent the applicant, Kings 55 Group, doing business as Le Philosophe Restaurant. They've been in operation since October of 2012, operating with a spotless record. They have an existing wine and beer license. They applied for a change of class.
You're aware the community board is opposing it?
Yes, I also attended the community board hearing along with Ms. Mock.
Yeah.
And we submitted at that time a petition with over 100 signatures of approximately 20-plus signatures from the local community, Bond Street, Bowery, some of the other side streets, Bleecker. The owner continued to collect signatures, and there's about 40 signatures from an updated petition that I have here.
What are your clients' hours currently?
For dinner on a weekday, we're open at 5:30 and the kitchen closes at actually 11 p.m. So
and what time do you close?
I think the restaurant closes at around 1 a.m. right now, because we don't serve food after 11 anyway.
All right.
And we do brunch as well, and pretty much just brunch, Saturday, Sunday.
The community board opposes this application, but says if we were to grant it, they're asking us to limit your hours to midnight. Would that be a problem? Would you be able to close at midnight? From what you said, it doesn't sound like it should be.
If I can keep my 1 a.m., that would be great, because actually the previous stipulation that we agree on was on 2 a.m. So I would say it would be fair for me to say that I would take the 1 a.m. just to suck it up and deal with this.
The premises also was previously licensed for an OP license. I have a copy of it, if the chair would like to see it.
Previous stipulation from when was till 2 a.m.? Here I see here it says 12 p.m. to 12 a.m.
I think what you're seeing is the Sidewalk Cafe, I believe, not the Sidewalk Cafe, I believe it's 12, not the inside.
Any steps?
The restaurant, just for background purposes, is a Zagat-rated restaurant. It's French bistro. They recently got a visit from the Michelin Group, and it's fine dining.
The original stipulation from December 2012 stated hours of operation will be Sunday to Tuesday, 11 a.m. to 1 a.m., and Wednesday to Saturday, 11 a.m. to 2 a.m.
So 1 and 2 were the hours.
Hmm.
Recommends denial unless the applicant stipulates closing on to the 12 and 7 days. Did you agree with that stip?
Did you agree with that stip or not? Did you sign it? Did they sign it?
Could you repeat that? We didn't hear that.
She said that it was recommended, the community board recommended denial of the application if you didn't agree to a 12 midnight closing
The community board
in 2012.
At the committee meeting that we attended, they did not even propose any compromise, and we were one of the last
But
items.
we're just talking about the hours right now. You wouldn't be compromising on the hours, because the hours isn't... Are you asking for extended hours as well currently? No, right?
Wednesday through Saturday, 11 a.m. to 2 a.m., Sunday to
Yes, they, Mr. Wu wants them, right,
Okay.
as the dining room, the original stipulation in the dining room.
We may have gone up from what the community board was originally talking about. I'm just inferring this because it was an RW.
Right.
Yeah, well, this is actually the signed stipulation.
Yeah.
Community board.
Yeah. So they just didn't get to 12.
The board said it was okay, but they're saying if we approve the liquor license, they'd like to, the OP then to bring it down to 1 a.m. or to midnight.
I think Mr. Wu would agree to 1 a.m. during the slow days and on
Okay.
He's got no adverse.
Right, he's got no adverse history over the past 3 years, I guess, 2.5 years.
And I think they're just asking for the 12 because that's what they do with,
Right, all.
with OPs. Yeah.
Okay,
So,
if you agree to the 1 a.m., I'll agree to approve.
yeah.
Well, what is your busiest days? Would the board consider 2 a.m. on Friday, Saturdays, which is his 2 busiest days, and the other days he will close at 1?
Again, I'd just like to mention this is not a lounge. I'm sure you hear this all the time. It's not a lounge. It's not a bar. It's actually a great French restaurant with a great reputation. But sometimes people, they do stay a little bit longer after they eat. They have a glass of wine, eat some cheese and stuff. So
How big is
if
the
you can-
bar area compared to the...
The bar has only had about 9 stools. That's a very small bar. It's an open kitchen.
How much seating do you?
Total
sorry?
about 40.
How much seating do you have altogether?
48. That's it.
Uh-huh.
Yeah, it's a very small restaurant.
And the outdoor
Small.
seating, what time do you serve alcohol to?
Until, what do I have, 12? 11? 12, yeah.
That's been approved. then.
Sidewalk Cafe, 11 p.m. Sunday, Thursday, midnight, Friday, Saturday.
Is that right? Well, I don't know.
I'll do it.
All right.
Yep.
Okay.
So we'll let you do
On
2
Friday,
o'clock on, is it Fridays and Saturdays? Is that what you're talking about?
Sunday through Thursday, 1 a.m.
Yeah, and Friday and Saturday too. Okay?
Thank you, Ronald. Thank you.
All right.
Thank you.
$192, $324 Brighton Beach Grocery.
$100? $200?
Nope.
Whatever.
190.
Oh, I'm sorry, I thought it was...
Is it 324?
Yes.
Good afternoon, Chairman Rosen, Commissioner Kim, Deputy Commissioners. Give my regards to Commissioner Green. I notice she's not here today. Hopefully everything's okay.
Sure, we will.
I'm not going to take so much of the board's time. My name is Noah. I'm the attorney representing the licensee here, 324 Brighton Beach Grocers, who are accused of selling 1 can of beer to an undercover SLA agent. After speaking to them, and even after meeting with the counsel's office here, Professor Gould, I've advised them just to set up a settlement, put a settlement package forward.
So what's the offer?
Oh, I'm sorry. I thought perhaps you would have a copy.
Yeah, the offer was just open-ended, and we would typically follow our guidelines with respect to that. Normally, in a case like this, it'd be $2,500.
Sorry, it's there's a 5-page settlement package that you should have. Right.
Now, the letter says that they'll take the ATAP course. Have they done that?
That's part of the settlement. Yes, but there are
no. The question is, have they done it? I know it's part of your offer, but they've done it.
Yes.
Do you have the certificates?
No. Well, I don't have them with me. I figured it would be based on the settlement.
I don't know.
This is a no contest. I believe perhaps there might have been a mistake. It was supposed to.
Okay, let me start over again. So they're offering to take ATAP, but they haven't taken it yet. Is that?
No, I believe the cashiers at that grocery have.
Okay.
I don't have the certificate with me. I can provide it.
Have they got a scanner? It says we'll get a scanner.
Oh, so you do have the settlement package in front of you?
Yeah. Yes.
Well.
Monetary offer in addition to all the compliance.
Yes.
I believe the letter.
I don't think you understand the procedure. We don't necessarily. It's not a settlement per se. I mean, we can impose a fine, right? And
I understand.
So stop calling it a settlement paper. Just tell us what the offer is, and answer the questions of the chairman. Did they buy a scanner?
No.
Not yet. Did they take the ATAP courses?
Yes, that they.
Not everybody. You said the cashier has taken it, but not all the employees have taken it.
I believe every employee that.
But you don't have any proof of that currently.
Provide it.
Okay, but so you know for certain that they all have taken the ATAP courses.
I believe I instructed them to take the ATAP class.
You've instructed them, but do you know for a fact that they've all taken the ATAP courses?
Everyone who works the till who sells alcohol has.
And how many people is that?
I believe there's just one person who sells alcohol.
So when you said everybody, you meant the one person?
Yes.
Okay, let's do this. We're going to adjourn this for 2 weeks and come back with a receipt for a scanner and with the whatever certificates for the ATAP course that show who took the ATAP course, okay? And normally this would be $2,500, but we might come down if you have the certificates and for the ATAP and you also show that they bought a scanner because there's no reason why they should be waiting to do that, okay?
Well, I understand there's a program in place.
I'm sorry?
I understand that there's a program in place that reduces the civil penalty by, is it a quarter?
It's the ATAP.
The ATAP class.
Yes.
Right. I'm looking to reduce that civil penalty even further with the other points here.
Okay, and I'm looking for you to bring in the documents that I mentioned. So we'll put this over to 224 and bring whatever you've got.
Sure.
Okay?
Thank you.
All righty.
205, VFB Corp.
I'm going to go take a bath.
205. Good afternoon, Matthew Leone for the licensee. Good afternoon, Chairman Rosen, Commissioner Kim, all members of the board. This is a conditional no contest plea for a $1,500 civil penalty. What happened here, this licensee had settled 3 cases, including there were a couple of sale to minors and some other violations for $13,500. This violation had occurred during the same time as the other violations that were settled. It's just that this violation came in from the police department to the liquor authority after we settled the other cases. So, but for that, the timing, the lag that.
It is later than all the other violations, though. It's not like it's right in the middle of them.
Well, you know what? It was the last one. It was the last violation that had occurred. Right, and then they were shut down I think this violation was May. Some of the other ones were February, March, and then they were shut down by the police department in June.
So this was a nuisance abatement?
It was a nuisance, yeah, right. And this,
You say shut down, how long were they closed for?
I think they were closed, I think it was about a week or so, and then they instituted all of the usual provisions where they have security, they have video surveillance, everybody is tip certified, they have the scanner, the electric scanner. Right, which I think at that point the cases were already settled. So really, if this had been received timely, it really should have been folded into the global settlement.
So they only got notice after the...
So that's what I want to be clear on. So your client was not told about these buys until after this last purchase that we hadn't included? Or do you know that? We don't. Do we know when the summons was issued? That's the May one.
Right.
Do you have anything on the prior sales that we already fined them for that would indicate that on any from which we could infer that they waited till that last buy, which is very possible because usually they do 3 and then they tell you. Here it's 4. I just like to know if there's anything that might indicate to us that to reinforce the assumption that these people weren't on notice. Yeah, and it was brought after the 4th sale.
It was in.
All right. Okay. All right, Jeff.
Received that in June of 2014.
Yeah, that's when they were. That's when they were closed under the nuisance abatement was in June.
All right. So, I'll take it, yeah, because we already did 13.5 and sort of been... Okay.
All right, it's accepted.
Okay, thanks.
2660 Silver Line Lounge.
This is a late renewal.
I did receive an email from the community board, and they have no objection.
Okay.
Impose, they'll take the late renewal penalty.
Okay.
That's our normal. 1,000?
Mm-hmm.
No, 2,000.
All right, I'll agree.
Okay. All right, thank you.
Thank you.
Well, yeah. Do you want this process through our normal channels with counsel's office to do the late renewal stipulation and pay the $1,000 without it having to come back to the board?
Yeah.
Okay, so we'll return to council and talk to them about $1,000. 266H, Billy Marks.
Good morning, Chairman and Commissioners. Dan Swanson here on behalf of the licensee. Submitted a conditional offer of no contest for $2,500 on also making the representation that we've been hired by the licensee to file and will file the alteration as soon as all disciplinary matters have been cleared. This is not the only pending one. We have one that we're just waiting for a decision from the judge. As soon as both are cleared, we'll file the alteration.
So are they serving any food now?
Yes.
What is that?
Since the inception of the last violation in which they were put on notice that they were required to have food, there's been food available every day. They have pizza and a pizza oven behind the bar. That's the purpose of the alteration, is to take from the stove and fryer, which are no longer there, on the recommendation of DOH since they were not being used. And they've installed somewhat of like a convection oven that they reheat/cook pizzas.
Why weren't they being used? They chose to stop serving food?
Well, originally they weren't serving food until they were giving the violation back in 2013. prior to when we were representing them. Prior to that, they were not serving any food. Then from that day forward, they've been serving pizza ever since. Yes.
What's been the delay in filing the alteration application?
Of course. We were just retained back in May of 2014. Prior council had brought a community board notice to the licensee. They had posted it in the premise. He actually appeared at the community board. He was not on the agenda, and the community board was unsure of why he was there. So he assumed that it was done, it was a mistake, or didn't need to happen. Once we got notice of this from Margarita during the pendency of a different notice of violation, that's when we researched it and realized that you guys had actually instructed him to file the alteration, that it never was done, and that's why we're here today.
You know, at the full board meeting, we were very clear to the licensee that he has to timely file an alteration application. It was made crystal clear to him.
The licensee appeared at the community board, and since he was not on the agenda, he thought it was taken care of and that there was nothing further to do.
Despite what he heard from us.
Were you here? Let me speak to the applicant. Were you here? Do you recall on May 2nd, 2014, you were at a hearing before this board?
No, sir.
You were never here?
No, sir.
So how were you notified? So you say you just got something in the mail?
No,
He had prior counsel. Matt Leone represented him, was here on that day, presented a CNC to you all. When he showed up when my client, the licensee, showed up to the community board and was not on the agenda, he assumed that there was nothing further to be done.
Mr. Leone, you represented him.
Maybe, oh, I'm sorry.
I'm not saying that Mr. Leone didn't explain it to her or not. When my client went to the community board and there was nothing further, he wasn't on the agenda. He didn't think anything further had to be done. I'm not sure.
Well, let's hear from Mr. Leone.
Yes, sure. And yeah, hopefully I can just provide some information that can help. When originally when we were here, we settled the previous case, right, and then we were instructed to to file the alteration application. What we did is we sent a notice to the community board a couple of days after this board meeting, and there were two things. There was the renewal application and also the alteration application. Within that 30-day period, we had to wait the 30 days. That's when the changeover occurred, right? So it's very possible. So we didn't appear. I didn't. Carrera McCallum or myself did not appear at the community board meeting. We did not notice that there was a community board meeting. There was some paperwork that was sent in. So I think it's very, very. And also the other thing is that this is Mark Penza, his brother Wilton. They run the bar together. They're co-principals. I think at that point Wilton was the one that I was communicating with in terms of what needed to be done as far as the application.
And neither of the principals was present at that May hearing before the board when we said that a timely application had been filed?
Yeah, that's true.
It was just you?
It was just me, and I think, so, and there were a bunch of different things going on between them getting the food in. I don't know if you remember, they tried an automat first, sandwich.
Yes, I do remember.
And the pizza. So there was a lot going on. They had that. They were instituting video surveillance. They were getting the scanner and the security guards. So I think it's very possible that with all of that going on and the change of and it just seems that sometimes the community boards themselves, especially, well, not especially, but sometimes, if there's more than one thing going on, it's very possible that they just didn't realize that it had to be done. So
okay.
I think there was a lot of moving parts going on at that time.
Yeah, and then the food's so the alteration application now has been filed, or you will file it?
We'll file. This is not the only pending disciplinary. There's one that we've had a hearing over a month ago, waiting for a decision to come back. As soon as that has been cleared, we will file the alteration.
So a year from now, which one of you should we talk to about it not being filed?
It will be filed. I will
You'll be
sure
the one.
my
All
office
right.
does it.
We can act
on alteration now to get
Yeah.
I was under the impression that if there was a pending disciplinary that we couldn't. Okay.
All right, so
We'll
we'll
file as soon as
accept
possible.
Yeah, I'll accept the $2,500.
Thank you.
All right. Yep.
179 Butterfield 8 NYC.
So what kind of place is this, Mr. Flynn? Butterfield 8?
This is a bar.
Family restaurant?
It's a bar restaurant.
right.
Family, I don't know. I've never brought my family there. This is the default. I actually saw it on the agenda the other day. We handled 2 other disciplinaries. We've been their attorney since the beginning of this. I called my client last night when I saw it.
All right, how's $1,000 to settle it?
Yeah, that would be fine.
We'll do $1,000.
All right, yeah, 1,000.
Thank you very much.
On your representation that it's a family restaurant.
No, I don't know about a family restaurant. I do know that the Board of Health violation is being dealt with, though. Thank you very much. Have a very nice day.
You too.
Enjoy your Valentine's.
That's it.
That's all the signed-in items.
All right, keep going.
Keep going. Okay. Not blended, but I'll figure it out. 176.
176, 10,000?
He offers, well, he's
No, I
not
know.
offering.
I'm counting at 10,000.
Just so you know, the Mayor of Hempstead did
I'll
inquire.
agree, 10,000.
Mayor of Hempstead inquired.
Did send us an email about whether or not he should appear. However, we responded that they are disciplinary matters. So they just looked at the calendar. They weren't sure if it was licensing items, but there was no position given.
He just got fined in November, and he's,
I'm fine
like,
with
3
that.
days later, he sold it.
10,000? 178.
Cancel and bond,
Yep, I agree.
180.
10,000.
Okay,
181.
1,500,
15,
182.
accept,
accept,
183.
accept,
accept,
5,000, accept,
184.
accept 3,000,
yep,
185.
accept 6,500,
agreed,
186.
accept 5,000.
agree.
187.
I had 13,005 and a suspension for 10 days. Something bigger than that? Is this one of those cases, again, this is like a notice issue, right? This is the
Yeah.
fourth.
It's a liquor
Yeah,
store.
yeah. When we do these things, usually we'll send a notice,
Right.
we will send a notice of pleading within a month, but this looks like one of those nuisance abatement type operations. And that's why I'm okay with
All
the
right,
13.5.
13.5 then, okay.
You're okay? 13.5. 188.
In this case, I actually had a letter of warning. Be fine with that, because they filed their DBA, but
All right.
I guess the person was away.
Yeah.
Letter of warning.
Got it. 189 and 190.
Except, although they did blow off Kerry 3 times, that's a concern, but I'll accept.
All right.
I will too. I think it was the other Kerry they blew off.
The other
not
Kerry.
you. Not you.
191.
Except,
I like the way that.
35, I'm sorry, 3,500?
Chairman, 191.
Yes.
35. Okay. Got it.
Yes, I agree
193.
with Commissioner Kim. As always.
Great. 193, revoke and bond,
194.
accept 500.
I agree.
195.
5,500, accept.
Accept.
196.
Offer 6,000, accept.
Accept.
197.
Offer 6,000, accept.
Accept.
198. The mayor also this was one of the other ones he inquired about.
Who's representing them? No, I mean, who's representing them? Do you know? Do you recall? Pretty scurrilous defense. Huh? Yeah, okay.
represented at the time.
I had 10,000.
10,000.
199.
I had 10,000.
I agree. Counter 10.
200.
4,000 accept.
I agree.
203.
Offer of 2,500 accept.
Accept.
204.
I just want to make sure the ATM was actually removed, but otherwise accept the 250 offer.
Yep.
206.
Keeping track of these, right?
Offer of cancellation and bond, accept.
Accept.
207.
Is this again, this is like the third sale to minor, fourth actually, there are 4 charges.
There's nothing else pending against them, and these were police referrals, but there was not from a nuisance abatement.
They do appear to predate.
Yeah, and they do predate the case that actually came before the board, so the timing on this isn't good.
Okay. All right, then I'll accept.
I would, yeah, I would.
10,000 accept.
208.
I think they need to change their license to a tavern license. It seems like what they're serving there, they're just ordering out for food. They can't do that, right? That's in violation.
Although it is, at least it's their restaurant that they're ordering from.
But the application said that they would have a kitchen.
Yeah, well, maybe we can get them in. Maybe they can extend the licensed premises to the restaurant. You want to get them in?
Yep.
Over to 224.
Please.
Sure.
209.
Offer 500 accept.
Accept.
210.
Offer 5,000 accept.
Accept.
211.
Offer 6,000 accept.
Accept.
212.
Offer 5,500 accept.
Accept.
213.
Offer 3,500 accept.
Accept.
215.
Granted.
Granted.
Charge withdrawn.
Yes.
Okay, thank you. Forgot this was ours.
220, right?
220.
Yeah, I had deny a lot of questions. I mean, the relationship, source of funds, previously revoked.
I was going to suggest we get them in.
Yeah, let's bring them in.
Because what surprised me was that we have nothing from the community board on it. That really surprised me.
And I went through because I
Yeah.
received all of my community board correspondence, and I do not have anything from this particular community.
Yeah, it's a 500-foot case.
Never received anything.
Terrible history.
Oh, so you never see anything from them on anything? Well, then let's not, let's just rule on it. So do you want to deny it or
Yeah,
get them in?
I mean.
And let's give the reasons clearly so that when we have
Sure.
a decision, the drafter will know exactly what our basis was.
My basis for denial was the relationship of the applicant to the previous licensee who had their license revoked in May of 2014. They share the applicant's Gloria Luna is the applicant principal's aunt, and Braulio Valles is a family friend. And Braulio Valles and Gloria Luna are they have the same last names as the previous licensees, Israel Valdez and Pedro Luna. Also, the source of funds, they borrowed money from Gloria Luna and Braulio Valdez. So based on that, my concern and my belief is that the current applicant is really a figurehead for the previous licensee who had their license revoked.
All right, I agree. And the applicant is also involved with a doggy daycare operation that she says she's going to continue, and yet she also represents that she's going to work 50 hours a week at the premises, which again sort of fits the concerns that you voiced. So I agree. Denied.
221 and 266A.
I think they have a stage where the seating is supposed to be. They don't have any food. There's a lot of issues. Yes, I think there's a lot of issues with this.
Want to get them in, or?
I'd like to get them in.
Okay. 224?
Yeah. So,
225.
I have denial of this. CB7 opposes it. There's a lot of noise complaints, and now they're looking to expand to the second floor. It's only going to compound the issues that are.
Yeah, I agree. We've got an email from Bronx Community Board 7 dated November 6th that talks about receiving numerous complaints from local residents, primarily related to noise, but including other issues. So they're objecting to this application. So I would agree, denied.
226.
I said yes.
Yeah, I agree. There's good distances between the stores. I don't think we have saturation issues.
Approved. 227.
I deny their fourth store within 4 stores within 1.3 miles. Fifth store is within 2 miles. It's 11,000 square feet of space already. Selling alcohol in that area. And we just issued a license, 21014. What's that? That's today, isn't it? A 1.3 mile away. I'm sorry. A year ago. Sorry, went back in time. So I vote to deny, based on saturation concerns.
It's a little closer for me. There's no protests.
They failed to answer the question of whether they'd be selling through the internet.
Oh, is that, so the application is incomplete?
Well, they didn't answer that question.
Liquor store, 227.
227.
Can I ask why we no longer ask that question?
It was decided in the lien Kaizen, that question was.
I wasn't invited to the lien Kaizen.
Asking if they're going to sell on the internet? Yeah, I think maybe we want to put that back, given the kinds of cases that are coming before the board.
Yeah, we want to expand on it, though, just to get the methodology.
All right, I'll agree and we'll deny.
228.
So again, the relationship of landlord and tenant. 2013, we issued a license right in that area. Sales the numbers aren't very large for all the stores.
Substantial distances, though, 3 miles.
3 miles
the closest
in Oneida.
store. I think based on the distances, I would approve it. None of them are on the same road, and with the closest store 3 miles away, I'd vote to approve.
Okay, I'll approve.
The closest store has increasing sales, too. So.
233, I had a request to adjourn. They recently hired counsel.
224?
224.
224.
234.
Grant reconsideration.
Granted.
238.
238. I had a grant originally, but then yes, grant.
Granted, withdraw the charge.
And withdraw the charge.
Counsel's office will withdraw the NOP.
Yes.
So you just want to return to council, or we can
No,
just
withdraw.
I can take care of it, yeah.
Thank you. I'll go to her Kaizen.
239.
Yeah, I mean, here I had, they still failed to comply with the fire marshals. I think they fixed one issue, but they corrected the heat detectors, but didn't address fixing the propane tank or the light, or the fire marshal's order. So I deny.
All right, denied.
$240.
I deny the request for reconsideration at $10,000 counteroffer.
65 counted with 10 new offers.
In this case, they did receive a DAT each time.
They received after the second sale, is what my note says.
It says the third one gets referred to SLA. So we got it after the third one, but I believe in here it said each time they received a disappearance ticket.
Commissioner Green's offer was $8,500, so their offer is less than that.
Their offer is a little lower. Well, all right, I'll accept the $8,000.
All right, I will too.
$241.
I accept the offer. Just cancel and bond.
Yep, me too.
242 through 244.
I'll accept their offer. 30-day suspension plus $5,000.
I agree.
246.
Offer of $3,000. Accept.
Accept.
248.
Again, I mean, the two sales to minors are on the same occasion on October 3rd, 14. So being the third and their offer of $15,000, I'll accept.
Accept.
252.
Letter of warning offer, accept.
Accept.
253.
$1,000.
I had a letter. I think most licensees don't know about
Sure.
pre-mixing.
We'll do a letter of warning.
254.
Offer of $5,500, accept.
Accept.
255.
Offer of $6,000, accept.
Accept.
256.
Offer of $6,000, accept.
Accept.
257.
Offer of letter of warning, accept.
Okay, we're tracking these. DBT ones.
Yeah, I run a report.
Yeah, good. Because then, after we do, well, you know they're all letters, I guess you go by your report. Because they may ask us down the road.
Yes, I'm in contact with OTDA.
Okay.
258.
Sorry.
I had a letter of warning. It's an ATM machine that they got rid of.
I'd say send a letter.
Oh, this one was interesting because we have instructed the licensee that it is a second business and a violation, and she disagrees with us wholeheartedly because it is not she who is making the profit from it, but we are explaining to her that she's permitting someone else to run a business in her licensed premise, and she just disagrees with us.
Well, I would send her a letter, and then if she continues, we go back.
I believe we have, but we never went there. This started as an EBT case.
Yeah.
That the swipe was at the ATM
Yeah,
machine.
I understand.
266C. This was care for them to appear.
Are we going to bring them in?
We tried.
Well, I sustained charges 1, 3, 6, and 7, dismissed 2, 4, and 5, and I had a $7,500 penalty.
No, you want to just impose the penalty? That'll get their attention.
Yeah, I'd like to do that.
Just impose the penalty.
75, Chairman?
Sorry?
I'm sorry, did you concur with 75?
Yeah.
Okay, thanks. 266F. They were also to appear.
They're a restaurant without a kitchen or food.
Yeah, I mean, if they're non-bona fide and they're supposed to appear and they didn't appear, can't charges are sustained and cancel and bond.
Okay.
We did get, okay, there's, how about we try before we
One more
take their
time.
license, maybe we send something certified to them where we got proof that they got it.
Okay.
I mean, if we were to take it for non-appearance.
They would get a 2-week plus, they would get a little bit more notice on the cancellation so they could come back at you while the order's out.
On the
For
recon. Okay, all right, I'll do that. Yeah,
Okay.
fine.
Then it's in their port. Thank you. On 266I, we have another request to carry over.
Did we ever get that town of Islip objection letter?
No, well,
I think that's
it's
where we
here.
carried it
This is
over.
their, someone just got, might have forwarded that one to you. But it looks like the way their court date's set up, it's going to be 3/24 would be the next board meeting. that they would-
3/24?
Oh, wait a minute, the next court date is March 11th, I think according to that.
Let's put it after that. Put it over.
3/24?
3/24.
Okay,
3/24?
3/24. Okay. 266K, the proposed rule.
We talked about this last time. These are going out for a public hearing. They're just tweaks to rules that haven't been looked at in 30 years. A lot of it just rescinds archaic provisions. Some of them liberalizes some advertising requirements. For example, there's a limit on how much the value of a display that a wholesale give a retail is like $150 or $200. That was 40 years ago, and the rules said that you were supposed to allow for consumer index increases every year. We never have. So it's updating and tweaking.
$150 40 years ago is a lot of money, huh? I'm okay with it. I accept.
Okay.
I'm okay with it.
Got it. 266L, we have another adjournment request. We've kind of marked it 2/24 for final. Mr. Levy is on point with that.
Yeah, we'll say that in the letter, that this is the final adjournment.
Yep. 266M, this was for the licensee to appear after they defaulted.
They were supposed to appear and they just never responded.
They didn't respond to the pleading, was it the pleading, and they didn't respond to coming here.
Excellent tacos, has no tacos.
Okay, cancel and bond to get their attention.
And 266N,
Yes.
delegation of authority.
Yes, thank you for changing some of that language and clarifying. Thank you, Secretary Held. I'm in agreement.
We've had so many tweaks over, we just had to reread it to. Yes. Well, I think there was zone 1, 2, and 3, and then things changed.
Because now that we're sharing applications between the zones and regulations on 3.
Why this part's taking Susan off the?
Because she has it.
It's already in the upper
so
part.
it's- okay.
It was, I think before, one of the many changes, it was specific to zone 2, so we.
All right, it's fine.
It's approved.
Good.
Good.
Okay, I have no other items.
Okay, so we are adjourned. Thanks.